Hey, everybody. Sorry about that. We totally thought we were live and we were not live. I forgot to hit the button. So,
We were
on that note,
talking.
yes. On that note, everybody, welcome to Wicked Truths and F Bombs. If you've never been here before, I'm Danielle. Those are my huskies,
And I'm Amy.
and we're happy you're here. We have a lot to discuss tonight. We're excited. Shouldn't say we are excited. We're always excited to come on YouTube. The information that we have tonight is very interesting, and it is, of course, more new documents.
Yes, we have more Joseph Ryan versus Lori the Beast Vallow.
Mm-hmm.
So, Zombie Maker, which probably isn't a really nice thing to say. I probably shouldn't say that. But before we get started, we have in our WTF group and on our page, we've started something called True Crime Tuesday. If you guys aren't in those Facebook groups, I encourage you to join. We just recently had a contest. We had 2 winners, and each of those winners received a gift card. One chose Amazon, and the other one chose Starbucks. So, if you like free stuff, if you like gift cards, if you like coffee, if you like little packages on your doorstep you don't have to pay for, and you're not stealing them from your neighbors, um, check it out.
Oh, Musty's here. Hey, Musty.
Hello, musty chesticles.
Yes. Okay, so I'm going to look at the chat for a minute before we get started. Sorry for the delay, guys. Like, we were totally having a conversation, and I'm like, wait a second, Amy. I don't think anybody can hear us because we're not live.
We'd been talking for about 6 minutes. And we
Yes,
were like, gosh,
yes.
we're so boring. Nobody's saying anything.
Yeah, I was like, why is the chat so dead? Like, there's no movement down there. What's going on? But so, anyways, here we are. We're usually a hot mess. Just take us as we are and we'll roll with the show, I guess.
That's right. Oh, one other thing I was going to say. Um, we did have some live feed from Frostproof if you're following that case. And we have a video we'll probably be dropping tomorrow. And it's a good one. It's an interesting one. So if you're not part of that group, please join that as well.
Absolutely. I think we're actually going to be live tomorrow night about the Frostproof case. We have quite a bit to discuss on that case. And today was an eventful day.
It was.
It was. It's been very, very busy all day. So I guess we'll go ahead and get started as soon as I get this document pulled up because I'm blonde. I'm slacking tonight. So
Have you ever seen the movie Earth Girls Are Easy?
I have not.
It's kind of like a cult classic.
Mm-hmm.
There's a song in it, and she's like, "'Cause I'm a blonde, yeah, yeah, yeah." I always sing that in my head.
All right. Make sure you guys stick out. Oh my gosh. Stick around for the end as well because we have some new information that we are going to share in regards to the investigation death of Joseph Ryan. So stick around for that. Let me get this document pulled up because I am completely unprepared and unorganized over here. And hey, it is what it is, right?
That's right. And those of you that are listening on the replay, sorry, we try to get started right away, but this is kind of our groove. So
it's what we do. We take your your constructive criticism is definitely always seen in your comments when you send it to us. So
we do listen. Oh, Amy E says, I used to have a license plate that said, "Watch out, I'm a blonde."
I feel like I need that.
She said no, but I got way too many dirty looks. So you were just a dirty blonde. It's okay. Silly. Hi, Glowing Ember, Maui Girl, Tracy L, Adriana. See a lot of familiar faces. Some new people in there too. Looks like Tom Rose is listening from Australia. Welcome.
Hey, what time's it over there in Australia? It's bright and early in the morning, isn't it?
He says it's 12:43 p.m.
Wow.
Yeah.
Okay.
Hi, Cherokee Girl 45. Gail Clark. Terry. Our super mods, our bomb squad. Amanda, Texas Gal. Thank you for being here.
Yes. So what we have tonight it's a continuation of the custody battle documents between Joseph Ryan and Lori Vallow. And these are actually very interesting. There's some very interesting things in them. This case continued over to Arizona when Lori moved to Arizona. And Joseph Ryan actually packed up everything he owned and moved over there so that he could be with his daughter. The lengths that Mr. Ryan went in order to remain a part of his daughter's life, and the lengths that he went to fight Lori to be able to be a father to his daughter are astounding and heartbreaking at the same time, because we know the end result. We know how all of this ended. We know that Joseph Ryan was found dead in his home, and it was presumed that he had been dead for a couple weeks when he was found, because he was decomposed when he was found. And we know that Tylee Ryan is dead and was buried in Chad Daybell's backyard. We also know, of course, that J.J. Vallow is dead and was buried in the same yard his sister was. So to read these documents and see everything that happened in the history of Lori Vallow is sometimes very, very, what is the word? Soul draining, I guess you could say,
Yes.
because it's like you just want to reach in there. You want to
And
reach
stop
inside.
it.
Yes, you want to reach inside these documents and you just want to stop it. So that as much as we love talking to all of you and being on here on this platform with all of you, we wish that cases like this didn't happen.
Right.
You know, it just,
Right.
you just,
Go ahead.
you just look back at this and you see so many opportunities, and it's so sad, and it's so, it's downright depressing. It is.
It is. Mm-hmm. There's always a spot in a case, at least one, where you feel like you could just take your little fingers and just pluck a little person out and
Right.
save them from what's going on,
Right.
or hit the pause button and have a come to Jesus moment with the people that made the mistakes in the past.
Mm-hmm.
You know, but in this one, it's sickening because it's over and over and over again.
Mm-hmm. It is.
And it's all documented.
Yes. Yes. So we are going to jump to this first document here. I got to pull it up here and start with that one. Make sure I got the right one. This file was sent to us differently than the other files, so bear with us because it was sent to us in, like, I haven't even counted, like 50 different files. So we have to look through file numbers and find the correct file number, and there's a whole long list of them.
Are we going to start with like the last three digits, 192 Joe's petition, or are we going to start with 838 last custody?
We're starting with 431-49182, I believe.
192.
431-491. Oh, wait, 431-49192.
Yes. Okay.
Yes.
Perfect.
Yes. And we are going to go down to, I gotta find it. Am I not seeing that one? I see 439-182. I bet that's it. It's probably a typo.
Yeah.
Okay, so we're going to go down to page 5. So the first document we're going to read is Joseph Ryan's petition for joint custody in the state of Arizona, specifically Maricopa County. This was filed on, I don't have a filing date. I'll find it, but I'll tell you when as soon as I know.
2/26/2013.
Okay, so 2013. Joseph Ryan made this filing for joint custody. And in it, he goes on to say, substantial and continuing changes of circumstances have occurred since the entry of the Travis County order several years ago. Our daughter is older and more mature and is approaching adolescence. Both mother and father have relocated permanently to Maricopa County, Arizona, and no longer have the same connection to and presence in Texas on which the current order and visitation schedule were premised. The Travis County order recognized that I should have substantial parenting time with my daughter, but the mother has unilaterally imposed conditions and restrictions that are not in the order and that have deprived me of significant time with my daughter. Mother has a history of alienating my daughter from me, which has been documented by court-appointed professionals, including a therapist in the Texas proceedings. Mother has interrupted the Travis County order to permit her to refuse to inform me of significant health issues that my daughter has had, and to refuse to allow me to see Tylee when our daughter was even in the hospital, even on Tylee's birthday. Mother has acknowledged that these activities are detrimental to the health and well-being of Tylee, and that the stress caused to Tylee may have contributed to our daughter's repeated occurrences of pancreatitis. Mother has also interpreted the order to allow her to prevent me from attending our daughter's activities, such as plays, and for mother to interfere with the parenting time that I do have with Tylee. Despite those restrictions, my daughter and I have a close and strong relationship, and I believe it is important for her and in her best interests for her to have as much time as possible with me so that I can be as good a father as possible. Tylee and I love each other and we enjoy spending time with each other. I am a different person than mother, and I am able to bring things to the relationship with Tylee that mother cannot. Yeah, he's pretty direct. One thing we were talking about the other day is that Joe, it's almost like when you go back and read these documents, Joe is telling the story and he is very direct. He is very honest. And I don't know if maybe he had a premonition or some kind of feeling, like he needed to be as direct and honest as possible because at some point, someday, somebody was going to review all of this and see his truth.
Right.
So it's very interesting. And then Lori actually replied to this petition, and we'll go ahead and read that one.
Okay, let's see. That is down on. I'm sorry, I'm scrolling through the orders.
Yep, it's actually highlighted in red. 4355 43551496.
Okay, I'm sorry. I thought it was still in this one. Sorry.
No, hold on. 4355.
You guys, when you get this file, you will understand. I see it. Okay.
Do you want to, and we're going to go to, on this one, we are going to go to, actually the whole thing, pages 1 through 8. So.
Okay. You want me to start?
Sure.
Okay. So let's see. This is in the Superior Court of the State of Arizona in and for the County of Maricopa. And I'll go ahead and tell you that this one was filed March 12th, 2013. And it's Ryan versus Vallow, response to petition to modify legal decision making, in parentheses, custody, parenting time, and child support, and mother's counter petition to modify parenting time. 2, enforce existing child support orders and obligations to pay medical insurance. 3, enter judgment against father for child support arrearages and order father to make payments on the arrearages. 4, appoint a child custody expert to perform a custody evaluation. And 5, award mother her attorney's fees and court costs. Respondent, Lori Vallow, mother, by and through undersigned counsel, hereby responds to the petition to modify legal decision-making, custody, parenting time, and child support filed by the petitioner, Joseph Anthony Ryan, Jr., father, and respectfully requests that the petition be denied. Furthermore, mother counter petitions the court to modify parenting time, enforce existing child support orders and obligations to pay medical insurance, enter judgment against father for child support arrearages, and order father to make payments on the arrearages, appoint a child custody expert to perform a custody evaluation, and award mother her attorney's fees and court costs. The basis for mother's response and counter petitions is as follows. Number 1, background. The parties were divorced on May 18th, 2005 in Hays County, Texas, pursuant to a final decree of divorce, case number 041277. A copy of the final decree of divorce is attached hereto as Exhibit 1. On September 22nd, 2006, a true and correct copy of the final decree of divorce was filed in the District Court of Travis County, Texas, and assigned a case number. See Exhibit 1. On October 8th, 2007, the parties were involved in a jury trial. A guardian ad litem was also present on behalf of the minor child, namely Tylee Ryan, date of birth September 24th, 2002. An order to suit to modify parent-child relationship was filed in Travis County, Texas on February 20th, 2008. A copy of the order in suit is attached hereto as Exhibit 2. The court found that the requested modification regarding conservatorship, for example, custody, should be granted, and the requested modification as determination should be denied. Pursuant to the order in suit to modify parent-child relationship, the court ordered that Lori N. Vallow and Joseph Anthony Ryan, Jr. are removed as managing conservators, and Lori N. Vallow is appointed sole managing conservator, and Joseph Anthony Ryan, Jr. is appointed possessory conservator of the following child, Tylee Ryan. On July 17th, 2009, the court issued an interlocutory order of July 17th, 2009 in suit to modify parent-child relationship. A copy of the, here we go again, interlocutory order, I'm so sorry you guys, is attached here too as Exhibit 3. Mother's appointment as a sole managing conservator was confirmed, see page 2 of the, I'm going to call it the IO, and father was ordered to pay child support. See page 13 and 14 of the IO. The court ordered father to pay mother child support of $1,500 per month, with the first payment being due and payable on August 1st, 2009, until father moved from Austin, Texas to Maricopa County, Arizona. After father moved from Austin, Texas to Maricopa County, Arizona, the court ordered father to pay mother child support of $1,000 a month. The Texas order decree was domesticated in Arizona on or about June 5th, 2012. A minute entry was issued by the Family Court Services on October 5th, 2012 that stated in part, it is ordered that father shall pay to mother and for child support the sum of $1,000 per month payable through the support payment clearinghouse by income withholding order effective immediately. Let the record reflect the income withholding order is initiated electronically by the above-named deputy clerk. It is further ordered that at any time an income withholding order is not paying the child support obligation in full, father shall make full and timely payments directly to the support payment clearinghouse in accordance with the instructions for making support payments through the clearinghouse attached hereto. Despite the order for father to pay child support through the clearinghouse in Arizona, father has, upon information and belief, made intermittent payments to the Attorney General's office in Texas. At this time, according to the most recent statement received from the Attorney General of Texas, Child Support Division, father owes mother the sum of $19,963.31 as of March 11th, 2013. And there is a financial attachment, an activity report. Father's request to modify legal decision, in parentheses, custody and parenting time, should be denied. The reasons set forth by father as to why the party's decree should be changed are denied by mother. There have been no substantial and continuing change of circumstances that warrant a change in parental decision-making or parenting time, at least as far as an increase in such time is concerned. Father's petition is made solely for the purpose. You're not going to believe what just happened. Are you there?
Yes, I'm here.
My whole document just shut down. So
Okay.
It took me a minute to get it up, and I'm so sorry.
What page?
I was down at the bottom of, I believe it was 8.
Okay. Let me make sure we're on the same document. Sorry, guys.
In the meantime, I'm desperately trying to get back there. I know exactly where it is on this sheet.
43551496. Okay, so the bottom of page 8. 4355.
I just got it back up, so I just panicked for a minute.
Okay.
Okay, so let's see. It's down at the bottom of this. Okay. Okay, so father's petition is made solely for the purpose of harassing mother because mother refused to waive outstanding child support arrearages and because mother was found to be not guilty of charges, in parentheses, interfering with judicial process brought by father following a bench trial. Father's allegations that mother has imposed conditions and restrictions on father and deprived him of significant time with the party's minor child, Tylee, is simply false. Father goes out of his way to undermine mother's time with their daughter and then becomes upset when mother does not give in to father's demands or want to talk to him. Father's request for joint legal decision-making is not supported by some of the more important factors set forth in the ARS, and then there's a report number. Specifically, the past and present abilities of the parents to cooperate in decision-making about the child has been rocky at best and has resulted in father initiating unfounded litigation against mother. The future ability of the parties to cooperate does not look promising. Father's request for increased parenting time is also not supported by the parties' history. Although the parties have an agreed upon parenting schedule in place, father has often failed to exercise his access on a regular basis. Additionally, the minor child's counselor, Lori Olson, has reported that the minor child undergoes a significant amount of stress when she is required to spend extended periods of time with her father. Thus, additional time with father is not in the minor child's best interest. Father's allegations regarding mother having a history of alienating his daughter from him is also false. Father's allegations of parental alienation were adjudicated during a jury trial that occurred in Travis County, Texas. The Texas court issued an order on February 20th, 2008. The parties were removed as joint management conservators, and mother, respondent in this case, was ordered to be the sole managing conservator. Additionally, pursuant to an IO of July 17th, 2009, in suit to modify parent-child relationship, the court stated, the court finds that the following orders are in the best interest of the child. It is ordered that Lori Vallow, mother, is appointed sole managing conservator, and Joseph Anthony Ryan Jr. is appointed possessory conservator of the following child, Tylee Ashlyn Ryan. The court would not have made these orders if mother had been engaged in parental alienation. This is just another example of father's fabrication of events. Go ahead.
Oh, you're fine. You're still reading. I'm sorry.
It's okay. Mother will not respond to the remainder of father's allegations regarding misconduct except to state that they are untrue. Father has fabricated and or exaggerated certain incidences involving mother in an effort to make her look bad in the eyes of the court. Fortunately, to date, prior judges in both the family law and criminal court arena have seen through father's ruses. With respect to father's request to modify child support, mother's position is that if modified, the child support should be based on father's earning capacity, reduced parenting time, and cost associated with health insurance that is actually being paid. Father previously indicated that he voluntarily quit one place of employment in order to set up his own business. Pursuant to ARS, there's a case number, determination of the gross of the parents, subsection E, and then this is a statement. If a parent is unemployed or working below full earning capacity, the court may consider the reasons. If earnings are reduced as a matter of choice and not for reasonable cause, the court may attribute income to a parent up to his or her earning capacity. In this case, father has previously refused to provide mother with information regarding his place of employment or his income. Mother does not know whether or not child support modification is warranted. However, any such modification should be based upon all of the factors set forth above. For example, income, parenting time, and insurance premiums. And if father's current income is less than at his previous place of employment, father should be attributed the greater income. In light of the above, mother respectfully requests that father's petition to modify legal decision-making, custody, parenting time, and child support be denied, or, if modification is warranted, that father's parenting time be reduced in accordance with past history and child support be based upon father's earning capacity, parenting time, and health insurance premiums actually paid. And then we go into a counter petition. As and for mother's counter petition, mother states as follows. Modification of parenting time. A substantial and continuing change of circumstances has occurred with respect to father's parenting time with the party's minor child, Tylee. As noted in the above response, father has failed to abide by the current parenting time arrangement and has chosen to have significantly less parenting time with his daughter than what has been ordered and or agreed upon by the parties. Moreover, due to father's increasing animosity towards mother in the presence of Tylee, the minor child's counselor, Lori Olson, has informed mother that it is very stressful for the minor child to spend extended periods of time with father. Due to these factors, father's parenting time with Tylee should be reduced in a manner that is consistent with father's parenting time history and in the best interest of the minor child, Tylee. Do you want to stop there and talk about, that was a lot. Or do you want me to?
No, I don't. Yeah, it's fine. We can talk about it.
I cannot believe that this is actually put in writing, that it is all turned on Joe's ruses, and the judges have seen through it, and it's false claims of parental. How does this happen?
Well, what's also interesting is that in Texas, Lori was so adamant about sexual abuse, right?
Mm-hmm.
Just downright adamant about it. And then she gets over to Arizona, and you notice she's not bringing that up anymore.
Right.
So it's just, she changes her agenda. She changes her story, and I don't know. I don't know how it's allowed to happen. We, of course, know how these documents end. The viewers, listeners do not at the moment. So I don't want to say too much, but I don't know. I don't know. It's all very hard to wrap your head around.
It's extremely disconcerting. And I think from my perspective, what I see is a campaign to make Joe feel like he's going absolutely crazy.
Right. Right.
Every time he tries to do the right thing, every time he kowtows to her and does what she wants, there's something wrong with it.
Right.
It's
It's
insane.
it's disturbing. I'll go. You got through page 8, right?
No, I'm only on page 6.
Oh, okay. All right.
You want me to finish to 8 and then we'll go on to the.
Yep, I texted you if you want to
I
check your
just
text.
saw it. Yes,
Okay.
thank you.
Yep.
Thank you for the heads up. All right. So, item 2 on this page is enforcement of orders regarding payment of child support and providing of medical insurance. So, it's just like pursuant to the IO and suit to modify parent-child relationship, the court, pursuant to an agreement between the parties, stated as follows. After Joseph Anthony Ryan Jr. moves to Maricopa County, Arizona, it is ordered that after Joseph Anthony Ryan Jr. moves from Austin, Texas to Maricopa County, Arizona, he is obligated to pay and shall pay to Lori Vallow child support of $1,000 a month, with the first payment being due and payable on the first day of the first full month he is moved to Maricopa County. It is further ordered that Joseph Anthony Ryan Jr. shall notify the court and Lori Vallow by U.S. certified mail return receipt requested of any change of address and of any termination of employment. This notice shall be given no later than 7 days after the change of address or the termination of employment. This notice or a subsequent notice shall also provide the address of Joseph Anthony Ryan Jr. and the name and address of the current employer whenever that information becomes available. It is ordered that Lori N. Vallow and Joseph Anthony Ryan Jr. shall each provide medical support and health care coverage for the child as set out in the order as additional child support for as long as the court may order Lori Vallow and Joseph Ryan to provide support for the child under sections 154.001 and 002 of the Texas Family Code. Father was ordered to pay child support, notify mother of the name and address of his current employer, and provide medical support and health care coverage for the minor child. Father has failed to fulfill all these obligations. For several of the months following the filing of the IO order of July 17, 2009, Father has failed to pay any child support or has paid less than his obligation. Father has also failed to provide mother with the required information regarding his employer and has allowed health insurance coverage on Tylee to lapse. As a result of father's actions, mother has had to borrow money from her current husband in order to help ends meet. Father appears to have the necessary funds to travel, hire a criminal defense attorney due to father being arrested for a DUI, and a family law attorney because father refuses to cooperate with mother in a reasonable manner. Mother has also incurred unnecessary expenses in trying to gain information regarding father's employer to determine whether or not a child support modification is warranted and has incurred medical expenses on behalf of her daughter due to father's lack of insurance coverage. An audit performed by the Attorney General of Texas Child Support Division indicates that father owes mother the sum of $19,000. God just did it again. $19,963.31 as of March 11th, 2013. Mother respectfully requests that this court issue a judgment against father for said amount and that said amount bear interest at the highest rate allowed by law. Mother further requests that father be ordered to pay a minimum of $200 to $300 per month toward the arrearage. Father makes various claims regarding his relationship with the minor child in order to bolster his allegations that he should have joint decision making and increase in his parenting time. However, based on father's inability to co-parent with mother and father's history of failing to use all of the time that is already allotted to him as parenting time, the concerns expressed by the child's counselor and father's erratic behavior, including the filing of unjustified legal actions against mother, it is not in the best interests of the minor child that joint decision making or an increase in father's parenting time be considered. In order for the court to fully understand the dynamics that are involved in this case and to help the court render a decision that it is in the best interest of the minor child, mother respectfully requests that the court appoint a child custody expert to perform a custody evaluation. Mother further respectfully requests that due to father having filed an unnecessary petition to modify, that father be ordered to pay for that evaluation. Attorney's fees. Father has filed frivolous pleadings in Arizona, setting forth various untrue allegations. Some of the allegations have even previously been adjudicated in the state of Texas. Father's allegations are based upon fabrications and/or exaggerations of events. In light of father's actions and mother having to retain the services of an attorney to represent her interests, father should pay all or a portion of mother's attorney's fees and court costs. Dated 11th day of March, 2013. Signed by the attorney for the respondent, Evans, Dove, and Nelson, PLC. And then there's a bunch of stamps you'll see on here, a list of who gets copies, like basically like CC's on an email. Can we talk projection much?
That should be her middle name.
Lori Project. I can't talk. Well, everybody needs protection against Lori. But yeah. You should have used protection with Lori. I don't know.
Boy.
Yeah.
But
so
Lori says she no longer needs. Oh, I get a lot of feedback. Okay, so yeah, there's a lot of projection there. It's crazy. She's a piece of work. I don't even have the words for her.
I think you're being kind.
I am.
Because
I'm highly censoring myself tonight.
I think she's a piece of something and it rhymes with hit. So that's me.
Shit?
No, don't say it. Now you gotta go brush your teeth.
I said it. All right, we'll move on to the next documents. Give me just 10 seconds.
Sure. In the meantime, I will look at the chat. Camilla Sweden says Lori only leave for money. Okay. Speedy Pilo. Oh, you're responding to somebody. Amy E. Was it possible for her to lie to get more? Yeah. You know, Glowing Ember, that's interesting. The picture of Joe with the orange shirt and the yellow vest just doesn't look like him. I thought that too when I was looking at them. It is him, but it just doesn't look like the other photos that we see. So, yeah. Susie says she has some projection on the tip of my boot for Lori. You guys are so funny.
That's funny.
Oh, look, my mom said hi, Amy. Hi, Mommy.
Wait a second. Okay.
Danielle,
all right, so I'm going to start.
Okay, I'm going to mute.
Oh, is your mom down there?
Yeah.
Hi, Amy's mom.
Danielle said the bad word, not me.
It was me. I cussed. All right. So the next set of documents is a great big another chunk of pages. So if I stumble over my words, please forgive me because I'm human and sometimes reading all of this can get a little difficult. This is Joe's statement to the court court. I'm sorry, this is not Joe's statement to the court. Yes, it is. It is his statement to the court for joint custody, and it's got some exhibits in there regarding Lori being in contempt, as well as Lori's attorney's letter to Joe and all kinds of good stuff. So I'll read the first chunk of this and we'll bounce back to Amy. This is filed on April 13th, 2017. Again, it is Joseph Anthony Ryan Jr. as the petitioner and Lori Noreen Vallow as the respondent. It says, comes now petitioner Joseph Anthony Ryan Jr. by and through his attorneys undersigned and hereby responds to mother's counter petition to 1, modify parenting time, 2, enforce existing child support orders and obligations to pay medical insurance, 3, enter judgment against father for child support arrearages and order father to make payments on the arrearages, 4, appoint a child custody expert to perform a custody evaluation, and 5, award mother her attorney fees and court costs. As a preliminary matter, the father objects to the counter petition as the document is not verified by mother. Without waiving said objection, father responds as follows. In regards to the modification of parenting time, the father affirmatively states that Tylee is happy while she is with her father, that she enjoys spending time with her father, and they have a close and loving relationship. The father denies mother's allegations that he has failed to abide by the current parenting time arrangement and further denies the allegation that he had chosen to have significantly less parenting time than ordered and or agreed by the parties. The father affirmatively states that he has been substantially, severely, and repeatedly denied his parenting time by the mother, and that mother actively has impeded and hindered father in the exercise of his parenting time. Father cites the following examples, which are illustrative of the game playing and I don't know that word. We need to get out that dictionary.com thing, Amy. I think we're going to need it tonight. Machinations?
Yes,
I said it right. Look at that.
Ding, ding, ding.
Machinations that mother has engaged in. Mother refused to permit the father access to their daughter when Tylee was hospitalized on her birthday, September 24th, 2012, for pancreatitis. So that's something else we can all add to our timelines, right? Tylee was in the hospital for pancreatitis on her birthday in 2012. Father was forced to enlist the aid of hospital personnel and present a copy of the order to be able to see his child. The mother refused the father his parenting time on Father's Day 2011 and was cited by the Gilbert Police for interference with parental rights, case number 11-10247. The mother refused the father his parenting time during the entire summer recess of 2011 and was cited by the Chandler Police for interference with parental rights, case number 11-71397. The mother admitted during her trial that she was aware in July 2011 that father desired to have his extended summer parenting time with their daughter during that month. The mother refused father his parenting time in the summer of 2009 and was found in contempt by the Texas court. Mother, through her attorney, unilaterally imposed restrictions on the father that were and are not in the order by dictating that father could not exercise his regularly scheduled parenting time during the Christmas holiday 2011 unless father reconfirmed his intention to exercise such parenting time. Attached hereto as Exhibit B is a letter from mother's counsel H. Lee Dove to father dated December 14th, 2011, conditioning the father's parenting time on father reconfirming the same honor before December 19th, 2011. It is noteworthy that this letter was sent by first-class mail during the Christmas holiday season and demanded the reconfirmation in the unreasonably short period of less than 5 days, 2 days of which were the weekend. The mother, through her attorney, again unilaterally imposed restrictions on the father that were and are not in the order by dictating that the father could not exercise his regularly scheduled parenting time commencing September 6, 2012, unless father reconfirmed his intentions to exercise such parenting time. Attached hereto as Exhibit C is an email and letter from H. Lee Dove to the father dated September 5th, 2012, conditioning father's parenting time on father reconfirming his regular scheduled parenting time. This demand for reconfirmation was sent by the mother's attorney late in the afternoon and placed the deadline on the reconfirmation by the following morning. So, in other words, they mailed it in the afternoon of one day and made a deadline for the following morning. The email to the father reflects that this was not sent to him until 3:48 p.m., and the copy fax to the father's counsel is time-stamped as being sent at 3:43 p.m. The mother, through her attorney, unilaterally imposed restrictions on the father by declaring that the father could not attend an extracurricular theater performance in which his daughter was participating and which was open to the public, but which was held during Lori's time. See the letter from H. Lee Dove to father dated June 27th, 2012, at paragraph 2, a copy of which is attached here to Exhibit D. The mother repeatedly has denied father his parenting time whenever father has requested a modification of the schedule to accommodate his work or other scheduling conflicts on his regular weekends by withholding their daughter for the entire weekend in question. The father has been assaulted and abused during exchanges of the child. Specifically, the father was attacked by the mother's brother, which resulted in the brother being convicted of assault. The father also was accosted and abused by mother's husband, which resulted in the Texas court entering a permanent injunction against the mother, prohibiting her from allowing her husband, Charles Vallow, from being present in future exchanges. Father has been threatened with retribution of seeking to exercise his parenting time with his daughter. Attached hereto as Exhibit E is a letter from H. Lee Dove to father dated May 29th, 2012, which states, due to your recent conduct, an attempt to have Miss Vallow prosecuted for custodial interference, she has authorized me to domesticate the Texas judgment and proceed with the petition for order to show cause regarding contempt against you. And while you may be able to cause her problems with custodial interference issues, she can definitely cause you problems. Father denies that Lori Olson is their daughter's counselor. Father affirmatively states that he has never heard of Lori Olson prior to reading her name in mother's response and counter petition. Mother has failed to inform father that their daughter has been taken to Lori Olson or any other counselor. Mother further has failed to inform father of the nature, purpose, dates, or any other information concerning their daughter's visits or visit with Lori Olson or any other counselor. Father objects to any alleged statements made or attributed to Lori Olson and denies that there is any substance or foundation for the alleged statements. If the party's daughter is to be taken to a counselor, father has the right to be consulted, to be informed of the date, time, and place of the appointment, to be present, to have discussion with the counselor, and to have copies of all records. I got to take a break for a second. Take a breath.
Okay. You want me to pick it up right here?
I think I can keep going. I'll go a
Okay.
couple more pages.
Okay.
All right. As far as the enforcement of orders, the father affirmatively states that he has been paying child support pursuant to the order and denies that he is in arrears as alleged by mother. Father further affirmatively states that the order expressly provides on page 16 that an accounting shall be conducted with respect to the issue of child support arrearage, that no such accounting has been conducted, and that the father is entitled to substantial credits which have not reflected on the Exhibit 4 attached to mother's counter petition. Father has repeatedly requested that the mother provide him with her records so that such an audit could be conducted, and mother has failed and refused to respond thereto. Father believes that he has made a substantial overpayment of his child support to mother. See the email dated July 17th, 2011, from father to mother, a copy of which is attached. The father affirmatively states that mother has had current and accurate contact information for the father at all times herein. In addition, the father has provided and continues to provide medical support and healthcare coverage for the minor child and within the order, and that the child is insured. The father empathetically denies that the mother's allegations that she has had to borrow money from her current husband to help make ends meet as a result of the father's actions, or that she has incurred unnecessary medical or other expenses due to the father's lack of insurance coverage. Father has been paying child support on a regular basis and is fulfilling his obligation of support. In addition, father is unaware of any medical expenses for the minor child, which were not covered by insurance, with the possible exceptions of deductibles and copays. Mother has failed to provide any information whatsoever concerning such alleged unnecessary expenses. Mother has also failed to provide any information concerning her income or any substantiation of the money she claims she borrowed from her spouse. It is believed that the mother is gainfully employed and has substantial income. Mother lists herself on her LinkedIn page as the assistant to the president at PFS Marketing, LLC in Austin, Texas, which is engaged in financial services. Mother also has a biographical sketch on the internet in which she proclaims that she is a group fitness instructor and a hairstylist and has traveled the country doing hair shows. That's the first I ever heard of her doing hair shows. That's funny. Um, The mother's counter petition on page 7, lines 5 through 7, make nebulous allegations and insinuations to prejudice father, including the complaint that the father appears to have the necessary funds to travel and to hire counsel. Mother alleges that the father refuses to cooperate in a reasonable manner, and refers to the father being arrested for a DUI. The reference to a DUI by mother is spurious and specious, and she is well aware that some penal codes is wholly inapplicable herein. Mother's complaint concerning father's travel also is spurious and specious, as father is required to travel for business in order to earn a living and be able to pay child support. Mother complains that the father has utilized funds to hire counsel, including family law counsel, but it is mother who has made it necessary for father to obtain legal representation and incur substantial legal fees. The mother's mention of father hiring criminal counsel is particularly insidious and noteworthy, as mother neglects to mention in her counter petition and thereby inform this court that she made the most outrageous, vile, and utterly false allegations against the father in Texas regarding child molestation. The father incurred significant costs and expenses in defending himself against these scurrilous accusations made by the mother, and the state of Texas refused to take any the state of Texas refused to take any action after investigating the charges. Um, Mother has acknowledged that her stepson has acted in sexually inappropriate manners in her home, prompting the court and family law proceedings involving her husband and his former spouse to place restrictions on the Vallow home, including keeping the stepson away from Tylee and Mother's two other children and video surveillance of the children's rooms. Mother has played similar games and engaged in manipulation directly in the family law proceedings. Mother denied father access to their child, and she utilized that lack of contact, together with the child molestation allegations, as a pretext to seek to terminate father's parental rights in Texas. Under local procedures, Mother's request for termination of father's rights was tried to a jury, which rendered its verdict in favor of the father. A period of reunification was instituted by the court, which culminated in the current order of July 17th, 2009. The order recites that the parties entered into an agreement which was presented to the court and entered on the record on July 17th, 2009, and the mother was represented by counsel therein. According to the Texas court, entered the interlocutory order that date. Nevertheless, subsequent to the interlocutory order, Mother moved to set it aside. The Texas court denied Mother's request, and the order was signed February 24th, 2010. Um, the mother's manipulations did not end in Texas. For example, the mother approached father and indicated that she would be amendable to a settlement of this matter. The father went to great expense and effort to prepare a comprehensive proposal, which was presented to the mother. However, the mother arbitrarily and summarily refused to consider that or any other proposal. And then it goes on to explain, it says Charles Vallow and Cheryl Wheeler, the Texas court admonished mother that if father and the child have been sufficiently reunified at the point in time, there would be a change of custody and the child would live with the father. The father has long sought to settle and resolve the parties' differences and put an end to the ceaseless litigation. We're going to take a break for a minute and discuss that. I think just everything I went over, because that is an earful. It's a lot to take in. Lori did a lot of things. She did a lot of bad things. She manipulated and alienated and lied and made stuff up that wasn't true. And
it's interesting that her delusions of grandeur and her over exaggerations came back to bite her. Now, so for instance, she travels around doing hair shows. She's a group fitness instructor. All of those things. I mean, ultimately, in my mind, she won. But again, very, very.
I don't feel like she won. I mean, she might have won for a short period of time after Joe was dead, but ultimately, everything we do in this life, no matter if you're me, you, somebody in the chat, or you're Lori Vallow,
Right.
it comes back to get you, and it's
did,
coming.
but she won in court, is what I'm saying, and it's just very difficult to sit here and see all of this and know that
She didn't win in court, though.
well, but she did, because she came out looking to, not to us in hindsight, but at the time to other people around her, it didn't seem like anybody thought she was a bad person other than Joe. And there weren't a lot of people supporting Joe other than his attorneys.
Yeah, that's true. But I mean, as far as like winning in court, the Texas courts even agreed that as long as they were reunified,
right,
that Tylee was to live with her father.
I'm not.
So
I should have refaced. I didn't mean like that. I meant like
she didn't win. She actually lost, and because she lost, she continued to fight and alienate, and I guess that's where she won, if that makes sense.
she won her own campaign is what I mean.
Yeah.
She runs a campaign, and I don't know. I think about. I mean, we've had these conversations before. Like I think about how sad Joe wasn't a perfect person. Okay, he wasn't. But how sad he must have been that he just watched people flock to her side and take her side, and everything that was coming out of her mouth was just garbage and lies.
Mm-hmm.
Really.
Yeah, absolutely. And I can't imagine how frustrating it is to see that, the courts are siding with you. The courts were
Yeah.
siding with Joe. Joe won over and over and over again, and no action was taken against Lori. There were some criminal cases that were brought about in regards to her not, um, following court orders and stuff like that. But if anybody has ever dealt with these types of situations when it comes to custody and visitation, the when you're found in contempt, or when you don't do what you're supposed to, it's usually just a slap on the wrist.
Yeah.
And that's the hard part, is knowing that Lori got away with it.
Yeah. It is. It is.
Yeah. So I'll keep reading this. Huskies are back. All right, let me hop back on this document here. I think we're gonna skip over the determination of the arrearages, just because they do go through these in this document, and
They're
it's
just
not
kind of, yeah.
right. So the appointment of a child custody expert, the father emphatically denies the allegations of mother as more fully set forth above. The father does not object to a child custody evaluation. The father objects to the mother's characterizations of the petition to modify as unnecessary, and requests that the court order that the cost of a custody evaluation be equally divided between the parties, subject to reallocation by the court. Then they discuss attorney fees, and we're going to go down to, that's his signature. We're going to Exhibit A, which we discussed earlier. I read it earlier. So Exhibit A is the original custody agreement that was finalized in Texas. I'm not going to read all that again because we've already read it. And then Exhibit B. Exhibit B is dated December 14th, 2011, and this is in regards to Lori actually keeping Tylee away from Joe over Christmas. And Joe had the right, it was awarded to him within the custody agreement, that he should get Tylee on certain days, one of them being Christmas. And this was typed on December 14th, 2011. It was typed by Lori's lawyer. And it says, "Dear Mr. Ryan, due to the upcoming winter break, my client needs to know whether or not you plan to exercise your visitation on December 26th or thereafter. Please let me know if you plan on or before December 19th, 2011. If I do not hear from you, then I will assume that you do not plan to exercise visitation, and will so inform my client." So mind you, it's typed on December 14th. He's expected to have an answer back by December 19th. But really, he didn't even have to answer this because there was already an order set in place.
Right. And it wasn't like it was a long distance or anything like that, like where you make airline reservations or a parent has to accompany a child, or, like
Right.
that's where you see stuff like that.
Right. Another one is where there's another one dated September 5th, 2012. And it says, "Dear Attorney Tennant and Mr. Ryan, please ask your attorney to send me a notice of appearance that you are in fact represented. I would not contact you at this time, but for the fact, according to Lori, you are to have access with Tylee tomorrow, September 6th, 2012, through Monday, September 10th, 2012. So they typed this on September 5th, the day before Tylee is supposed to go with her dad. It's mind blowing. She simply needs to know whether or not you are going to exercise your access during that period of time. If she or I do not hear from you by tomorrow morning, then she will assume that you are not going to exercise your access and will accordingly make plans with Tylee. On the other hand, if you are going to exercise access, please let us know right away. Lori needs to be able to make plans without Tylee if you are going to have her. This is a very simple request for information regarding your plans with respect to Tylee this upcoming weekend. I look forward to hearing from you. So it's literally sent the afternoon before, and this is his visitation. He doesn't have to verify that he's getting his daughter for visitation.
This is just bullying.
What's also interesting, so these are telling, because you see how Lori wants to reaffirm, right, that Joe is going to get Tylee.
Mm-hmm.
How come he laid dead in his house for 2 to 3 weeks and Lori wasn't wondering why Joe wasn't getting Tylee?
Because Lori doesn't care.
No, it's because Lori knew.
Wow.
That's my opinion. Because any other time she was
Pounding him,
finding petty little reasons to stop him from seeing his daughter, or like trying to just confirm that he was getting his daughter when it was already set in stone that he was.
Mm-hmm.
But he lays there dead for 2 to 3 weeks, and she wasn't worried about whether he was getting his daughter then, right? It doesn't make sense.
It
I
does.
don't know. So that was the counter complaint. I'm not going to read any more of it. It's pretty in depth. It's very in depth, actually. We can jump to the next part.
There is something interesting here, though, just because I've heard this from other people. He's trying to find a way to exchange the child so he doesn't get attacked or she can't accuse him of anything. And when he comes to something reasonable like the police station, she's like, no, that would scare Tylee. No.
Right. And that's
No.
after Alex had tased Joe in front of Tylee, and Charles had acted a fool in front of Tylee as well.
Yeah. It's just interesting. It's like, oh no, not a good idea. Too scary. Much too scary.
For sure. It's crazy. It's interesting how things were different in Texas, though, because reading through these, you can see that Lori was actually getting to the end of her options. Her list of excuses was running out. Her list of accusations was running out, and Joe Ryan wasn't giving up.
Right.
So
what do people like that do? Yeah. They move.
Mm-hmm. They take off to places like Hawaii.
Well, they go anywhere new where nobody knows them so they can recreate their campaign again without prejudice. The problem is that she had some court records that kind of toddled behind her.
Right. Yeah. So I guess we will jump to the next document.
The one that ends in 611?
Right.
Okay. Okay. Let's see. This is filed May 6, 2013. And it starts with modification of parenting time. Mother reiterates her position that the party's minor child will be happier having less time with father rather than more. Pursuant to heading 1 of father's response entitled Modification of Parenting Time, father provides several examples of mother's alleged misbehavior. Father's examples set forth gross misstatements of fact, exaggerate in a negative light mother's behavior, and completely fail to recognize father's egregious conduct during the past several years. Father has caused mother to spend literally thousands of dollars responding to father's baseless allegations against mother. Oh my God. And to third parties and local law enforcement officials. Examples of father's misstatements and exaggerations are as follows. Father claims mother refused to permit father access to their daughter, Tylee, when Tylee was hospitalized. This is simply not true. Father was at the hospital every day when Tylee was in the hospital. Mother called father and let him know she was in the hospital, and he was allowed to come and see Tylee every day, even though it was not his visitation time. On Tylee's birthday, father texted mother late in the day and said that he wanted to come see the child. Mother told him it would be better the following day because Tylee was tired and mother's family was there, with whom father does not get along because they tase him. Shortly thereafter, mother was contacted by hospital security stating that father was present in the hospital and that he insisted on seeing his daughter. Mother stepped outside the minor child's room with her family. Father came into the child's room, watched her sleep for approximately 30 minutes, and then eventually left. According to mother, father always likes to create some kind of drama and then blame her for it. Regarding Father's Day, mother states that she never, to her knowledge, cited the Gilbert police. However, many times after the parties have a dispute, father contacts the police department and attempts to have charges issued against mother. In any event, if there was a citation, it was never acted upon. Regarding mother's alleged refusal to allow father parenting time during the summer recess of 2011, father had mother charged with interference. However, after a trial, mother was found not guilty. Father, who had only exercised 1 weekend of visitation during the entire school year of 2010 to 2011, leading up to the summer he referred to, informed mother that his work schedule would not permit him to visit with the minor child during the summer. Mother thought at this time that it possibly had to do with father's DUI charges, but then father sought to obtain interference charges against mother. Regarding mother being found in contempt by a Texas court in the summer of 2009, that only occurred because mother and her attorney at that time had a misunderstanding as to father's access time. The only thing that happened was that mother had to give father a makeup weekend, which mother states father never exercised. This matter happened before the final court order of 2009 and has already been litigated. Moreover, father was found in contempt on several occasions, which he fails to mention. With respect to father's allegations that mother unilaterally imposed restrictions on him, these are examples of father's exaggerations of the situation that existed at the time. Father is constantly asking mother to change the visitation schedule at the last minute. Thus, mother was simply asking father to plan ahead so there would be no misunderstandings as to when father's parenting time would occur. Mother did inform father that he was not welcome to attend a show by Broadway Kids in which Tylee was participating, but that was because of father's past antics, which ended up causing a disruption. Mother had tried to work with father to the best of her ability, especially in light of father's ever-changing schedule. Many of the issues that father raises in response were litigated in Texas and are also and are also so old as to be irrelevant to the current proceedings. Father's statement that he has been threatened with retribution for seeking to exercise his parenting time with his daughter is disingenuous. Mother asked court to read the entire letter upon which father's claim is based so that it can be seen the context within which the letter was written. As mother stated previously, father likes to begin problems with mother, but then becomes upset when his actions blow up in his face. Despite what father says Lori Olson is the Despite what father says, Lori Olson is the minor child's counselor and therapist. She will be made available to testify at future hearings if necessary. Zanny the nanny. Mother's claim that father owes child support arrears is supported by arrearage calculations received from the state of Texas. Father's denials do not change this fact. Moreover, father claims that he is entitled to substantial credits to offset any arrearages owed. However, father has failed to provide any evidence of credits to which he might be entitled. Father further claims that mother has his insurance information. That is not true. To date, mother has not received insurance information from father despite her multiple requests to father to provide such documentation to her. Furthermore, mother has provided father with copies of unpaid medical expenses which father has failed to pay. In response, father denies several of mother's allegations. However, he has provided no competent evidence to support his denials. Father raises the issue of child molestation charges having been brought against him. It is mother's position that she has never made any false allegations about father regarding child molestation. She still feels that father did molest their child and notes that such accusations were never proved to be untrue. Moreover, this matter was already litigated prior to 2009. Father's statements that mother acknowledged some inappropriate activity by her son is irrelevant to these proceedings and is inaccurate. These matters were also litigated prior to 2009. Father claims that mother filed a request to terminate father's parental rights in Texas and that there was a verdict rendered in the favor of father. This is not true. There was no verdict in favor of father. The jury did not terminate father's parental rights, but did take away father's right to joint custody and gave sole custody to mother. Mother has made multiple attempts to resolve this matter with father and offered father a payment plan to pay back some of the child support arrearages, but father declined. Mother did not arbitrarily and summarily refuse to consider any of father's proposals. In fact, mother considered everything, but she was unwilling to waive all the child support arrearages, so no settlement was reached. Let's see. Mother provided information forwarded to her from the state of Texas. The information documented the arrearages owed by father. Father claims that he's entitled to some kind of credit against the amounts that were not paid as child support. Mother has requested documentation as to the amount and nature of those credits, but father has failed to provide them. So this just goes back and forth. You know, it's Lori's position that Joe owes a substantial amount of back child support payments and that the interest continues to accrue and that those arrearages at the highest rate allowed by law. Moreover, when the total amount of the arrearages has been calculated, mother requests that father make payments toward the arrearages at least at the rate of 10% of the outstanding amount owed. And let's see, amount of child custody expert. Based upon father's conduct towards mother these past several years and the information the minor child has provided to her therapist, a child custody evaluation may be necessary in order to determine a parenting schedule that is the best interest of the minor child. And then we go on to attorney's fees. Let's see. In accordance with ARS, father has greater resources to pay mother's attorney's fees and has taken unreasonable positions during this litigation and prior litigation. It is father who continues to file unfounded petitions and complaints against mother. Father has even gone so far as to send letters to mother's employer, in an obvious attempt to have her fired. Father has gone for over 9 months at one time, not paying any child support or acting in the minor child's best interest. Father's prior objective seems to be harassing mother until she becomes so frustrated with him that she simply gives in to his requests. And then it's concluded right here. Due to the information provided by the court, mother respectfully requests that father's petition to modify legal decision-making, parenting time, and child support be denied, and that mother's counter petition be granted. Dated this 3rd day of May, 2013. Signed by Lori's attorney, and then all the copies that go out to everybody, and then the verification statement. So it's just certified by a notary public.
Yeah, it's a lot of back and forth, and they actually went to trial over this. and I'll start reading those. I'm going to look at the chat for a minute. I don't. Are people in the chat making claims that Alex impregnated Melanie Pulowski? Because
Oh gosh.
I mean, let's just be. Come on, you guys. This is twisted enough. She married Ian in November. She's pregnant. She's having a baby. I don't think there's any doubts anywhere that Ian is the father. And I don't believe that Alex was having sex with his niece. Um, she was with her husband by all accounts. I mean, we've seen it on the news over and over again how he was like, wiretapped
Right.
and recording what she was saying and keeping files on his computer. And those are just unfounded claims and adding more stuff to this already way twisted web of lies and deceit and murder and everything else. So,
It's really, this is just a side note that really annoys me about reading this is that there's like, there's a whole religious doctrine, like, but not even really religious doctrine because we know it's all like convoluted. But when I'm saying here, like, mother says and father says, I just feel like I'm reading cult doctrine, like,
mhm.
or like an old, like, I don't know, here on Walton's Mountain script or something. It's just, oh God, it's
Okay,
crazy.
so again for the chat, Brandon and Melanie were divorced almost a year ago. She's been married to Ian since November, and she's having Ian's baby. It's not Brandon's baby. She hasn't even had any physical contact with Brandon or her other 4 children in I don't know how many months. So, um, yeah. Yeah, that's just no. It's Ian Pulowski's baby. It's her husband's baby.
It's okay. It doesn't matter who claimed it. Just stop it.
Yeah. And okay. So, we'll move on to the next document. They go to trial, and it's interesting to see what happens during the trial, after trial, and all of that. Let me pull up this document. This is um it's a complete witness list. Actually, it's a joint pretrial statement, both parties witness list. I'm just going to read that really quickly so we know who is on the witness list and their pretrial statements. And it says, comes now petitioner father Joseph Anthony Ryan Jr. and respondent mother Lori Vallow by and through their respective attorneys of record, undersigned and pursuant to Arizona Rules of Family Law Procedure, Rule 76, hereby submit the following joint pre-trial statement. This is a post-decree matter which is before the court on father's petition to modify decision-making, parenting time, and child support, and mother's counter petition to modify parenting time, enforce existing child support orders, establish arrearages and attorney fees. It gives the names and addresses of the parties. Let's see. This matter is set for trial on February 20th, 2014. The names and dates of birth of all minor children, it's just simply Tylee Ryan. She was the only child involved in all of this. Let's see. So, the respondent and mother's witnesses. This is Lori's witnesses. Lori Vallow is listed as her own witness. Charles Vallow is listed as Lori's witness. Lori Olson, who was a licensed psychologist, is listed as a witness. Janice Cox was listed as a witness. Summer Shiflett was listed as a witness. Cammie Clausen, director of Broadway Kids, is listed as a witness. Colby Ryan was listed as a witness. Joseph Ryan was listed as a witness. Any witnesses listed are called by father. are not called to testify. Oh, so any witnesses that were listed or called by the father, whether or not called to testify, are also subject to being witnesses and cross-examined by Lori. So the father's exhibits that he asked to present at this trial: a memory box, book, Father's Day card, vacation notes, and letters from Tylee to her father. A letter from Olivia to the petitioner. Again, Olivia was, I don't know who Olivia was. She's not listed here. But, okay. A certificate of completion of co-parenting class. An audit letter and accounting dated May 5th, 2010. And a letter from Kay Taniguchi to Judge Livingston, filed in Travis County, Texas, dated November 30th, 2009. Emails between the parties regarding father's or petitioner's proposal to resolve disputes. Emails between parties regarding the respondent's failure and refusal to produce accounting records. Order of enforcement by contempt. A fax from John Hindera, dated February 5th, 2008, to Mary Fogel and J. Terry Weeks, enclosing 2 pages of purported medical notes regarding Tylee, a notice of filing medical records accompanied by affidavit filed in Travis County courts, a transcription of Lori Noreen Daybell's deposition given on May 20th, 2009, correspondence from H. Lee Dove to petitioner. That's listed several times for all the stuff that he had sent Joe, trying to pull some fast ones and Lori get away with not sending Tylee to her dad. Phoenix Children's Hospital records regarding Tylee's hospitalization in May of 2008. An order and petition and intervention of Carlos Laredo, filed in Travis County. Emails from respondent to petitioner, dated April 10th, 2013, April 2nd, 2011, and October 6th, 2013. Emails from petitioner to respondent, dated August 26th, 2013, March 21st, 2013, March 11th, 2013, and June 17th, 2011. Exchange of emails between the parties on April 25th and 26th, 2012. An email from the petitioner to the respondent, dated June 28th, 2011. The mother's objections to father's exhibits. She basically looks like she objected everything and then had her own exhibits where she was trying to contradict Joe. So they go to court and they have a trial, I believe. Yes, they had a trial, and it's interesting what happens after that. I got to pull up the next exhibit here. Sorry, guys. It makes it harder when there is like multiple files versus one huge file that we're looking at, because we're looking at about, I didn't even count them. There's a lot.
There's a lot.
Yeah, it's like 600 pages or something like that, but they're all broken down into files.
Yeah, 2 or 3 pages at a time. So she's got to.
We'll go to Lori's position statement that she made.
All right, you want me to do that one?
Sure.
Sure. Hold on one second. It's right here.
Yeah, like Christina said, there's 64 separate PDFs to go through. It's a lot.
So basically, I think we can kind of summarize this. So this one starts with Exhibit 1, Mother's Position Statement, Objections to Father's Exhibits. And so they're like numbered. She's got hearsay, relevancy, hearsay, lack of foundation, authentication, settlement negotiations, Rule 408, relevancy, authentication, that goes on and on, over and over, redundant, late disclosure. Then she goes down and she says, on item 1, whether or not father's petition to modify decision-making for the minor child should be granted. The parties have a long, tumultuous history, even continuing after their divorce in May of 2005. Since mother was awarded sole managing conservatorship of the party's daughter, which basically means mother was granted sole custody in the state of Texas, there has been no change of circumstances warranting father be given joint decision-making authority. In fact, it would not be in the best interest of the minor child to revise the current decision-making arrangement due to father's contentious behavior. Granting father equal decision-making will only encourage father's behavior and make co-parenting even more difficult between him and mother. The parties were divorced, we know, in May 2005. Hayes County, Texas, pursuant to the final decree of divorce. On September 22nd, 2006, they did the final decree. In October 2007, the parties were involved in a jury trial. A guardian ad litem was also present on behalf of the minor child, namely Tylee Ryan, date of birth, September 24th, 2002. An order in suit to modify parent-child relationship was filed in Travis County, Texas on February 20th, 2008. The court found that the requested modification regarding conservatorship, for example, custody, should be granted, and the requested modification as determination should be denied. Pursuant to the order in suit to modify parent-child relationship, the court ordered that Lori Vallow and Joseph Ryan are removed as managing conservators, and that Lori and Vallow is appointed sole managing conservator, and Joe Ryan is appointed possessory conservator of the following child. We've seen this previously. Let's see. On July, we've seen this too. They go back and they say, on July 17th, 2009, the court issued the interlocutory order of July 17th, 2009, in suit to modify parent-child relationship. That order was signed by the court on February 24th, 2010. Mother Lori Vallow remained as the sole managing conservator. The allegations raised by father as to why the parties' decree should be changed are denied by mother. There has been no substantial and continuing change of circumstances that warrant a change in parental decision-making or parenting time. Father's petition is made solely for the purpose of harassing mother because mother refused to waive outstanding child support arrearages, and because mother was found to be not guilty of charges interfering with judicial process brought by father following a bench trial. Father's allegations that mother has imposed conditions and restrictions on father and deprived him of significant time with the party's minor child are simply false. Father goes out of his way to undermine mother's time with their daughter and then becomes upset when mother does not give in to father's demands or want to talk to him. Father's request for joint legal decision-making is not supported by some of the more important factors as set forth in ARS, and there's case number, specifically the past and present abilities of the parents to cooperate in decision-making about the child has been, I'm not reading very well and I apologize, specifically the past and present abilities of the parents to cooperate in decision-making about the child has been rocky at best and has resulted in father initiating unfounded litigation against mother. The future ability of the parties to cooperate does not look promising. This is kind of, there's two paragraphs that kind of go back into everything we've talked about before. They talk about, this is just another example of father's fabrication of events. And then it says, mother will not respond to the bulk of father's allegations regarding misconduct, except to state that they are untrue or taken out of context by father. Father fabricates and/or exaggerates events involving mother in an effort to make her look bad in the eyes of the court. Fortunately, to date, prior judges in both the family law and criminal court arena have sought through father's ruses. Let's see. During these proceedings, father has provided several examples of mother's alleged failure to cooperate with him. Father's examples set forth gross misstatements of fact, exaggerate in a negative light mother's behavior, and completely fail to recognize father's egregious conduct during the past several years. Father has caused mother to spend literally thousands of dollars responding to father's baseless allegations against mother to third parties and local law enforcement officials. Example of father's misstatements and exaggerations are as follows. Father claims mother refused to permit father access to their daughter Tylee when she was hospitalized. We already read this statement. Is correct. Regarding Father's Day, mother states that she was never, to her knowledge, cited by the Gilbert police. C. Mother's alleged refusal to allow father parenting time during the summer recess of 2011. Mother being found in contempt by a Texas court in the summer of 2009 that only occurred because mother and her attorney at that time had a misunderstanding to father's access time. With respect to father's allegations that mother unilaterally imposed restrictions on him, these are examples of father's exaggerations of the situation that existed at the time. Father is constantly asking mother to change the visitation schedule at the last minute. So we talked about that. Mother has tried to work with father to the best of her ability, especially in light of father's ever-changing schedule. Many of the issues that father raises in his pleadings were litigated in Texas and are so old as to be irrelevant. Let's see. She believes that father's parenting time should not be increased. The simple fact is that due to an erratic work schedule or for some other reason, father constantly has to cancel or revise parenting time. Father's inability to abide by his current time schedule is one of the primary reasons there is so much contention between the parties. Awarding father more time will only serve to increase the conflict. Based on the above, mother's position is that father's parenting time with Tylee should be reduced to 1 weekend a month so that father can focus on spending that time with the child and hopefully not need to reschedule as often. Child support should be calculated using current guidelines. Pursuant to answers to interrogatories, father admitted he earned $7,000 a month, even though he has not provided his 2012 or 2013 tax returns or W-2 statements. Mother is unemployed and is a stay-at-home mother. She has an infant at home for whom she provides care. Both parties provide insurance coverage for the minor child. Father states that his insurance for the child costs $320 per month, and mother avows the insurance coverage she provides for the minor costs $373.13 per month. Mother's insurance covers medical, dental, and vision care. The minor child is over the age of 12 and no daycare is required. Depending on the amount of parenting time father is awarded, the visitation offset will vary on whether or not father owes child support arrearages to mother, and if so, how much. At mother's request, the Office of the Attorney General of the state of Texas provided her with a financial activity report. Pursuant to that report, father owes $22,214.16 as of January 9th, 2014. The Office of the Attorney General, Texas Child Support Disbursement Unit, also prepared and provided a true and correct copy of the computerized official child support payment records of the Texas Child Support Disbursement Unit. This report shows all payments made by father from July 13th, 2006 through January 9th, 2014. The total paid by father was $88,435.50. Mother reviewed her decree of divorce and subsequent orders issued by the state of Texas to calculate how much father should have paid. See attachment. At a minimum, father should have paid $128,400. Deducting father's ordered payments from the amount the records of the Attorney General showed he paid demonstrates that the father owes mother the sum of $39,964.50. Let's see. $128,400 to $88,435.50 as and for child support arrearages. However, this figure is not quite accurate because it fails to take into account payments father made outside the system that mother acknowledges. For example, mother stated during her deposition several years ago that father was current in his child support payments as of February 2006, even though the records showed no payments. If we deduct the total sum of those payments that should be made, or $15,000, then the amount father owes is decreased to $113,400. Father also made two payments totaling $2,250, one in April 2006 and one in May 2006. Taking all these deductions into consideration, father owes mother $22,714.50. On whether either party is entitled to an award of attorney's fees and court costs. Father has filed multiple frivolous pleadings in Arizona setting forth various untrue allegations. Some of the allegations have even previously been adjudicated in the state of Texas. Father's allegations are based upon fabrications and/or exaggerations of events. Additionally, father has greater resources to pay attorney's fees and court costs than mother. Father earns approximately $7,000 per month, while mother is a stay-at-home and therefore unemployed. In light of father's actions and the differences in the ability to pay, father should pay all or a portion of mother's attorney's fees and court costs pursuant to ARS Section 25-324. So that is a lot of back and forth, and I think the rule on that is pay your money through the court.
Yeah, it definitely was a lot of back and forth. And Lori, clearly, I've been saying, I've said it over and over again. She used her kids for money, all of them, every one of them. I mean,
Oh yeah.
they were her paychecks, and Tylee was, I think, her biggest paycheck, sadly, because Joseph Ryan paid a lot of money in child support. He actually had a very decent income, and child support is based off of income usually. So when this first started out, I want to say Joe's child support was actually $2,500 a month.
Right.
When it started out in Texas. And then we see it here being lowered to $1,000 a month. And yeah, he paid a lot of money. Plus he carried insurance on Tylee as well. And Lori did not. From my understanding, the insurance that Lori provided for Tylee was through Charles. So,
but she paid $373.13 a month, Danielle.
maybe that's where she borrowed money from her husband. She was in debt to her husband or something.
But she was also an employee of that company, so she probably got commission on that policy. So
good Lord, it's enough to make your head hurt.
It does.
So this eventually went to. I was wrong, I think, when I said it went to trial. It went to what was called if I can pull it up. It went to an under advisement ruling and evidentiary hearing. So, under the advisement ruling, and this is dated on June 6th, 2014, this matter was taken under advisement following an evidentiary hearing regarding the petitioner father's petition to modify decision making, parenting time, and child support, and the respondent mother's counter petition to modify parenting time, enforce existing child support order, establish arrearages and attorney fees. The court has reviewed the history of this matter, including the final decree of divorce and subsequent orders entered into the state of Texas and domesticated within this court. The Parenting Conference Statutory Report dated October 3rd, 2013, the testimony of the parties as well as the exhibits submitted, and after significant deliberation of such evidence and arguments of the parties, makes the following findings and orders. The petitioner, father, and respondent, mother, have one minor child, currently 11 years of age. The parties were divorced in the state of Texas with the entrance of a final decree of divorce on May 18, 2005. Subsequent orders were entered modifying the provisions of the original decree, regarding custody, parenting time, and the division of holidays, with the last modification defined by an interlocutory order of July 17th, 2009, in suit to modify parent-child relationship. Currently, mother has what is referred to as a sole managing conservatorship of the party's minor daughter as defined by Texas law. Mother wishes for the court to confirm that mother shall continue to exercise sole legal decision-making authority and that father's parenting time be reduced to 1 weekend per month. Father is requesting an award of joint legal decision-making authority between the parties and that his parenting time be modified to a 5-2-2-5 schedule or another equal parenting schedule. Father also seeks clarification of the parties' holiday schedule. The court finds that the mother and father have one minor child in common, Tylee Ryan, born September 24th, 2002. The parties and the minor child have resided in Arizona continuously for at least 6 months preceding the filing of the petition for dissolution. The court therefore has jurisdiction as Arizona is the home state of the minor child. Further, the court has jurisdiction pursuant to ARS 25-402. The court further finds that the Federal Parental Kidnapping Prevention Act does not apply and that no international law concerning the wrongful abduction or removal of children applies. Best interest findings. Section 25-403A enumerates specific factors for the court to consider among all factors that are relevant to the child's or children's physical and emotional well-being. The best interest of a child is the primary consideration in awarding legal decision-making authority and parenting time. In making the legal decision-making and parenting time determination, the court is mindful that as a matter of public policy, absent evidence to the contrary, it is in a child's best interest, 1, to have substantial, frequent, meaningful, and continuing parenting time with both parents, and 2, to have both parents participate in decision-making about the child. As a precursor to the analysis of the child's best interest, and because of the parent's inability to reach an agreement, the court considers the following issues regarding the parents. 1, whether a parent's lack of an agreement is unreasonable or is influenced by an issue not related to the child's best interests. The lack of agreement between the parties is a result of a long-standing distrust and interparental conflict that have created different perspectives as to what is in the best interest of the minor child. The past, present, and future abilities of the parents to cooperate in decision-making about the children to the extent required by the order of joint legal decision-making. There have been difficulties for the parents to co-parent, resulting in poor communication and distrust in resolving disputes. The parties have utilized therapy and a parenting coordinator to resolve past issues. 3, whether the joint legal decision-making arrangement is logistically possible Even with a difficult history, joint legal decision making is logistically possible with assistance. The court further finds as follows regarding the child's best interest pursuant to ARS 25 403A: the past, present, and potential future relationship between the parent and the child. The parties were originally divorced in the state of Texas on February 24th, 2005, and the parties' current parenting plan is defined in an order entered by the District Court of Travis County, Texas on February 24th, 2010. The mother and the minor child, Tylee, relocated to Maricopa County, and the father subsequently followed an order to exercise regular parenting time. Tylee has a bonded relationship with both parents. 2. The interaction and interrelationship of the child with the child's parent or parents, the child's siblings, and any other person who may significantly affect the child's best interests. The mother lives with her current husband and 2 children, including Tylee. Father has two The father has 2 older children who reside in Texas. Tylee describes in her interview with the parenting conference provider a positive and supportive relationship with both mother and father. Tylee reports having quality experiences with father during his parenting time. The child wishes that her parents would stop fighting. 3. The child's adjustment to homeschool and community. Tylee is well adjusted in her performing arts school and feels comfortable in the households of both parents. Even though the parents claim that their child has had difficulty in adjusting between the parents' households, there does not exist evidence indicating that the minor child is not personally well adjusted in school or in the community. 4. If the child is of suitable age and maturity, the wishes of the child as to legal decision making and parenting time. Even though Tylee has not directly indicated her wishes regarding decision making and parenting time, her indicated comfort in both households appears to support the need to assure that the minor child has a significant relationship with both parents. 5. The mental and physical health of all individuals involved. While all parties resided in Texas, the mother accused father of sexually abusing the minor child and sought to terminate father's parental rights. Apparently, after a full investigation by the Texas authorities, the matter was dismissed when a grand jury refused to issue an indictment. At that time, the father had minimal contact with Tylee. A reunification process was ordered for the parties and the minor child at the mother's expense. Even though Tylee continues to see a therapist, the father testifies that the reunification process has been successfully completed. A review of the parties' psychological evaluations and psychosexual evaluations by the parenting conference provider does not indicate any concerning behaviors or mental health issues of either parent. 6. Which parent is more likely to allow the child frequent, meaningful, and continuing contact with the other parent? The father alleges that the mother has interfered with his court-ordered parenting time in the past by relocating to Arizona without notice and by refusing to allow parenting time with father, resulting in a resulting in a charge of custodial interference in 2009. Currently, both mother and father state that they would allow frequent and meaningful contact with Tylee and the other parent, even though the mother is presently asking this court to reduce the father's parenting time to only 1 weekend every month. 7. Whether one parent initially misled the court to cause an unnecessary delay, to increase the cost of litigation, or to persuade the court to give legal decision-making or parenting time preference to that parent. No claim has been furthered that either parent has intentionally misled the court concerning the issues pled. 8. Whether there has been domestic violence or child abuse pursuant to ARS 25-40303. The mother alleges incidents of domestic violence committed by the father during their relationship, but not amounting to a finding of significant domestic violence. Child Protective Services was involved with the family in Austin, Texas in 2007 based upon allegations of sexual abuse by the father. The investigation lasted 1.5 years, whereby father submitted 2 psychological evaluations in 2008. The mother states that there was not enough evidence to convict the father. 9. The nature and extent of coercion or duress used by a parent in obtaining an agreement regarding legal decision-making or parenting time. The parents have not reached any agreements regarding decision-making or parenting time. 10. Whether a parent has complied with Chapter 3, Article 5 of Title 25, Arizona Revised Statuses. The mother reports that she completed the Parent Information Program requirement in August of 2013. The father completed a class in Texas named Putting Kids First that may meet the requirement. Any party who has not completed the Parent Information Program requirements, or of course, the court finds compatible, shall not file any subsequent pleadings to modify or enforce any provisions of this order until a proof of completion has been filed. 11. Whether either parent was convicted of an act of false reporting of child abuse or neglect. The answer is no evidence has been submitted regarding this item. In addition to the foregoing, the court must also consider any history of domestic violence or child abuse, any substance abuse issues, and any sexual offender issues. The court finds that neither mother nor father furthered any allegations regarding substance abuse under the provisions of ARS 25-403.03. The court further finds that the prior allegations furthered by mother of sexual offender issues under the provisions of ARS 25-403.25 have been previously discussed herein. Legal decision-making authority. Legal decision-making authority, as defined by ARS 25-4013, means the legal right and responsibility to make all non-emergency legal decisions for a child, including those regarding education, healthcare, religious training, and personal care decisions. For the purpose of interpreting or applying any international treaty, federal laws, a uniform code, or the statutes of other jurisdictions of the United States, legal decision-making means legal custody. The court finds that based on the above, it is in the child's best interest that mother and father be awarded joint legal decision-making authority regarding Tylee Ryan. It is therefore ordered awarding mother and father joint legal decision-making authority regarding Tylee Ryan for the purpose of this order. Joint legal decision-making means both parents share decision-making and neither parent's rights nor responsibilities are superior except with respect to specified decisions set forth herein. Shared or joint legal decision-making authority does not necessarily mean equal parenting time. So the specific terms of the decision-making authority, the parental decisions shall be required for major issues in raising the child and in meeting ongoing needs. When they arise, each parent shall give good faith consideration to the views of the other and put forth best interest to reach a consensus decision. If the decision involves medical or schooling issues, the parties may further elect to seek input from treating physicians or educators. Both parents shall be provided with such input. If they cannot agree after making a good faith effort to reach an agreement, any such major issues shall be presented to the court for resolution. A parenting coordinator. In the event the parties are unable to reach mutual agreement of an issue involving the minor child, either party may request of this court for the appointment of a qualified parenting coordinator to assist the parties to reach agreements or make recommendations to the court for consideration and determination. Parenting time. The mother and father shall share joint legal decision making. The following parenting plan maximizes each parent's parenting time to the extent it is practical and in the child's best interests. It is therefore ordered the parenting time shall be exercised as follows. The mother and father. The mother and father shall share equal parenting time on the following schedule. This is a 14-day, 2-week schedule, which continually repeats as follows. Week 1, father, Wednesday, Thursday, Friday, Saturday, Sunday. Mother, Monday and Tuesday. Week 2, father, Wednesday, Thursday. Mother, Friday, Saturday, Sunday, Monday, Tuesday. Week 3, which is actually week 1 repeated. Father, Wednesday, Thursday, Friday, Saturday, Sunday. Mother, Monday and Tuesday. Week 4, which is actually week 2 repeated. The father, Wednesday and Thursday. Mother, Friday, Saturday, Sunday, Monday, and Tuesday. The chart shows which parent shall have the child overnight. The schedule shall begin at 6 p.m. on Wednesday, June 11th, 2014. The exchange time shall be 6 p.m. It goes on with a holiday schedule and all of that, and summer schedule. The holiday schedule is pretty standard. The summer schedule, the father shall have parenting time for the month of July as currently defined by the parties' Texas order, including mother's parenting time during said month. So Joe was to have Tylee for the entire month of July. During subsequent summers, starting with the year 2015, and each summer thereafter, the parties shall use a week on, week off schedule. The exchanges shall occur at 6 p.m. on each Friday. Going on, what does it say? Additional legal decision making and parenting time orders, general parental communication. It is a furtherance of the child's best interest. The parent shall confer and shall consider the views of each parent. They're supposed to get along and they're supposed to talk. It's basic stuff beyond that. So Joe was awarded joint custody. He got both joint decision making and joint time with his daughter. He was to have her 50% of the time. And I believe that was put in place and that was going well. And then Lori took off to Hawaii. So that's interesting that as soon as she wasn't getting her way and as soon as Joe got joint custody, she took off not just to another state in the US, but she took off out of the mainland.
Yeah,
and went
she completely absconded.
Yes, she did. She did. So then Joe had to fight her some more. Imagine that, right?
No.
Let's pull up that document. Let's see. Oh, there's other things in here. Like Lori requested that Joe pay all her attorney fees.
Yeah.
Oh my gosh. But I want to pull up where she took off to Hawaii. I just got to find it. So, anybody who wanted to know what this isn't the end result, but a very solid result here was that Joe did get shared parenting. Lori no longer had full custody of Tylee. And he essentially won. You know, he was supposed to have his daughter 50% of the time. So let me find.
What number are we on now?
I'm looking for it. One moment. find it. I thought I had it highlighted. Oh, okay. We are on 555 62766.
Okay. I am looking. No, it's right there. Duh. Okay. Let's see.
I have it up. I can start on it.
Oh, I have it up. I was just trying to find a place to skip where we weren't reading all the. I think we all know who the respondent and all that stuff is. So I was just trying to find a place to start. And Tylee and her birthday.
So
Yeah.
what this document is Joseph Ryan went and filed another petition to the court because Lori not only took off to Hawaii, she did it without permission.
Right.
And he was awarded joint custody. So she just up and moved. And she blamed it on saying and said that her husband received and accepted a job opportunity in Hawaii. Specifically, the same location where she was staying this past winter after her kids were buried in Chad's backyard.
Coincidence.
Mm-hmm.
And this is okay because it benefits Tylee, so he should be okay with it.
Right. Joe stated in these documents the relocation is not being made. Oh, I'm sorry. This might have been Lori's statement. Lori said that the relocation is not being made to frustrate the relationship between Tylee and father because mother has actually offered that Tylee remain with the father during the school year or pursuant to some other schedule that will enable both parties to spend quality time with Tylee. That's interesting in itself because Lori fought so hard from all of her slander and accusations in Texas to all the shenanigans that she pulled in Arizona up to taking off to Hawaii. She offered for Tylee to live with her father during the school year. I truly feel like that's a testament, like, as a mother, because if Lori or any mother ever believed the accusations that she brought against Joe or ever had any proof that they were true, I don't believe that she would have offered for Joe to keep Tylee 9 months out of the year.
No, absolutely not. It's at her convenience.
Right.
And the rest is just garbage.
So it's let me find a page to start on this one. Joe actually, she served Joe with on May 30th, 2014, the mother served father with a notice of relocation and sent father's attorney a letter asking that father work with mother so that a long distance parenting arrangement could be established. On June 3rd, 2014, the court issued an under advisement ruling setting forth its determination that mother and father shall share joint legal decision making and joint parenting time. The mother accepts the court's decision. The mother attempted to resolve this matter with the father by first securing the written consent. The father refused to give consent. So when Lori asked to take off to Hawaii, Joe said no, understandably. And they exchanged several emails between each other. On June 12th, 2014, the mother sent father an email reiterating that her husband had accepted a job in Hawaii and that she was going to move from Arizona. On August 1st, 2014, the mother stated that she would like her and father to sit down and talk about the best schedule for Tylee and that she saw two options available. Either Tylee could come with the mother and go to school in Hawaii and visit with the father, or Tylee could stay in Arizona and go to school in Arizona but visit with the mother. On June 12th, 2014, the father responded with an unreasonable third option, wherein he stated that the mother's husband should move to Hawaii without the mother and that the mother and Tylee remain in Texas. Father also stated, I will oppose Tylee moving to Hawaii. June 13th, 2014, the mother asked father again if he would be willing to get together to discuss the logistics of the two options she proposed. Um, so we'll read the emails because they're in here, I believe. Basically, Lori wasn't supposed to move. She was supposed to have Joe's consent to move, and he did not give her consent. He actually told her no. She moved anyways, and they went back and forth in some emails about this, but she still took off to Hawaii. So let's
She
see.
does what Lori wants to do.
Yeah. Just gotta find the emails. Or scroll to the emails, not find them. I have them. I have to scroll.
I'll look at the chat while we do that. Let's see. Tylee was a zombie at this point, according to what Melanie Gibbs said, because a zombie at 12 and Tylee is 13 or 14. Tylee was probably starting to see through her mother's good word and machinations. Yes, machinations. Yes, I
I
think
think
that's true.
Tylee was actually 11 at this time.
Okay. Well,
She was
something
almost 12. Yeah.
right, about 11. So just getting to be the age where daughters aren't as much fun for moms. Yes.
Mm-hmm.
Mm-hmm. Let's see. You guys are talking about stuff on Netflix. I wonder whose idea it was to move to Hawaii. Well, duh. Britt Billets, you want to know who Joseph Ryan is? I can refer you to our Facebook group. There is a wonderful timeline that will show you everybody involved. Let's see. She'd never let him have Tylee for school year if all that BS was true, in my opinion. Yes, I absolutely agree.
I
And
find it interesting that she wanted to set up a meeting between the two. Like Joe Ryan would ever sit down with her
right.
in a closed confined space after he had been attacked, tased, and there were multiple threats within the emails. I mean, one of the threats Charles said, I don't know if I have it verbatim, but I think I have it pretty much memorized in my head. When we hit, you'll never see it coming.
Well, not
So,
only that, if he met privately with her ever, he probably would never get legal representation again. Because
right.
no attorney is going to deal with a client that would put themselves in that position. So he'd be he'd be screwed in so many ways. He'd either die or not die and never have another attorney.
And she'd make if he didn't die in her presence, she'd have all kinds of accusations.
Right.
He's just honestly, I'm not kidding when I say my head hurts right now. It hurts.
Right.
She gives me a headache because she's a disgrace. Sofatato, didn't Charles say that Lori had been a little weird for a long while, but not like it was when he called the cops? So if you go back to our previous lives, when we went over some other documents, Charles was aware that Lori believed that Tylee was Lori's reincarnated dead sister. Charles was also aware that Lori believed that her dead attorney was coming to visit her at night. And Charles is 100% a victim of murder. He was murdered. He was. He was also very well aware of what Lori Vallow was and what she did. So, it's a that's actually a touchy topic, I think, because there's just things that make you say, why did he stay? Especially when it comes to his own children being drug into this and Lori making accusations about his kids. So that's a touchy subject. I have to disagree. I do not believe he found out too late. I think he how do I say this, Amy? I think he was aware of what Lori was. I think he was aware of what she was, but she was okay with Charles and she loved him. It was when Lori stopped loving Charles that he was like, oh
Right.
gosh, I know what she's capable of. Does that make sense?
Well, that's when it became despicable to him enough where he was throwing his hands up in the air and whatever. But up until that point, as long as he was getting Lori's love, he tend to look the other way, even when she started dragging his own children into things.
Right. Right.
Mhm.
And people I think don't really want to hear that, but that's the facts. That's the truth.
It
It doesn't
is.
it doesn't change the fact that Charles was murdered. He was
Right.
shot in cold blood. He was killed. He is a victim of murder. So, that's a touchy subject. It is.
It is, but I
Um,
mean, it's worthy of mentioning it
it
because
is. It is.
it happens all the time. Did they start on page 13?
Hold on one moment. I'm going to think. Thank you, Heath Shea. That was very kind of you.
Yes, thank you very much.
Let's see.
The first one I found was Tylee in Hawaii.
Yeah, yeah. Do you want to
Okay,
read that one?
sure. It's dated April 22nd, 2014. Let's see. From oh God, that's too recent too, whatever. Okay, so it's from Joseph to Lori. Lori, I want to make sure we address the rumors of you moving to Hawaii with Tylee and issues I see right now. I appreciate you giving me some confirmation Charles could have an opportunity and for you to possibly move with Tylee. I need to be very clear we will use the court process for me to oppose the move. I mentioned this before jobs are accepted, moving commitments are made, and then the court may not grant the approval for the move that can be costly and disruptive on your end. For Tylee, kids talk to kids. Kids talk to parents, and parents talk to parents. I found out about the potential move through this channel and not directly from you. That would have cut off the rumor mill right there from the beginning. What's more concerning is an understanding of Tylee going to Kauai in the, I don't know how to say this, so our Hawaiians and residents down in the chat maybe can help me. Is it Kapaa area with you, Charles, and your mom to look at lease houses instead of her being in school? Returning hours before school on Thursday with Tylee have no sleep is also something that's not advised. Tylee has already missed some portion of 35 days this year. Not one day of this has been with me. Also, with Tylee being told to not tell me, not only does she have to keep a secret, but her friends that come to the house have to keep a secret. In addition, by having Tylee directly involved in the middle of conversations and Trip has to be harming her that can trigger her pancreatitis. She and her friends are upset she will be moving and possibly not see each other again. As you know, this is very dramatic for children. I can also sense Tylee is worried she and I will not see each other as much as we do now. That's the most upsetting. She has been experiencing this for the past 9 years, and now she is in the middle again. Please take all of this into consideration before involving Tylee again. From the rumor mill, it's my understanding once the adoption of the second special needs baby is completed, you plan to move. We haven't discussed directly, so can only go by rumors and third-party conversations. I am overall concerned and disappointed with the lack of discussion and planning together. If these are not rumors, how will it be in the best interest of Tylee's health, welfare, happiness, and development as she goes from our little girl to a young lady with close interaction between both parents being very important? Since we have not had a chance to discuss in person, I want to make sure my concerns and intentions and the best interest in Tylee are very clear. If you would like to discuss as parents, I am always open to that being the best approach. Regards, Joe. So,
All right, I'll read the next one. It's probably one from Lori. I,
hi,
I,
Joe.
I get to lead. I get to
Hey, Joe. Hey.
fill in the Lori Vallow.
Mm-hmm.
Ugh, yuck. Okay.
You get to be Lori for style.
Ugh. On Thursday, June 12th, 2014 at 5:58 p.m. Charles Vallow, aka Lori Forstyle at iCloud.com, wrote, "Hi, Joe. I am happy to tell you what is going on. Charles did accept a job in Hawaii. It is a great opportunity for us to get to live in paradise and learn of the culture there. I would like it if we can sit down and talk about what the best schedule will be for Tylee since the move is coming up fast. We are moving by August 1st. I see it as only two options. Either Tylee comes with us and goes to school in Hawaii and visits with you, or she stays here with you and goes to LFPA and comes to Hawaii to visit with me. I don't think we need to go to court to figure this out. Please let me know if you would like to talk about it as her parents. I am sure we can come up with a schedule that will work for everyone. I have been in touch with two different school options there, as well as the Wilcox Memorial Hospital, two different GI specialists, and two different pediatricians. They are now aware of Tylee's health concerns. It is an island, but it is still the U.S. and very modern in every way. Let me know if you want to talk. Thanks, Lori."
Okay. This is June 12th, 2014. It's Joe to Lori. Option 3. Charles moves to Hawaii and both of Tylee's parents stay here. It's easier for him to commute back and forth than Tylee commuting. Why does Tylee Why does Tylee lose parenting time when it's Charles that wants to work in Hawaii? If you want to move to Hawaii, I cannot stop you. I will oppose Tylee moving to Hawaii. Joe. I like Joe.
Yeah, Joe seemed like a pretty upfront guy. On Friday, June 13th, 2014, at 9:57 a.m., Charles Vallow, aka Lori Forstyle at iCloud, wrote, "Hi, Joe. I can understand that you are upset about the move. Still, I need to know if you would like to get together and discuss the logistics of options 1 or 2. Do you want to agree on a visitation schedule that Tylee is happy with, or do you want the attorneys to handle it? Also, according to the new ruling, Tylee's time with me starts on Monday at 6 p.m. I don't know if that messes up your plans for your trip, so I am open to discussing this summer schedule with you as well. Please let me know if you are interested in talking about it or not. Thanks, Lori."
So, we're moving anyway. So, hi, Joe. Hi, Joe. We're moving anyway. We're moving.
Joe says no, and Lori says, "Well, tell me what option you'd like, 1 or 2."
I know you are, but what am I?
Oh my gosh.
It's so crazy. So you want me to read the attorney letter that falls in between? It's not real. It's the same old.
Right.
Okay. So, Exhibit 7 is from Joe to Lori, and it is dated June 13th, 2014 at 12 p.m. MST. Hi, Lori. Hi, Lori. The court ruling is clear. Either you have written consent from me that Tylee can move, or you have orders. I'm not giving you written consent, therefore, you need to have orders to move. The process is also clear that unless you are giving me written notice you are moving without Tylee, I do not see how lawyers cannot be involved. It's your decision to move that forces me once again to pay attorney fees and to have us stand before Judge Dunn. In addition, you are sending me mixed messages. On June 9th, Tylee has to start packing up her room. Next email, the impending move is August, nearly 2 months later. I will get back with you on the Monday exchange since there are considerations I need to make. Thanks, Joe. Good Lord. I just...
There's more. We just got to get into the next file, guys. Sorry, we have no control over how many files they sent us and getting in and out of them.
Is it 616?
Let me scroll. I don't know. Would you say 616?
I'm using the last three numbers of file, but that was the end of that one.
Yeah.
End of the line. So, no.
Okay, so
616 is Lori Vallow's request that Joe pay all her fees.
We need to go to 572-72201.
Okay.
So they go back and forth. Lori files a change of address from Arizona to Princeville, Hawaii.
No.
Of course, there was a modification of the custody advisement ruling agreement proposal that Tylee lived primarily with Joe in Arizona and visiting with Lori in Hawaii. And that was actually put into place. We'll read that.
And his child support was terminated.
Yes, his child support was terminated.
Dun, dun, dun. What do you think got Lori angry there?
Right.
So
572-722.
let's see. Sorry, guys. Let me take a look at the chat.
Lori did adopt JJ. The chat's talking about adopting JJ. Her and Charles did adopt JJ. This was all actually going on during the adoption of JJ. And if you noticed in one of those emails, Joe pointed out that Lori was adopting a second special needs child, which is interesting when you look at the custody agreement that we discussed last week regarding William LaJoya. Did I say it right?
Yeah.
And Lori Cox, Vallow, whatever you want to call her. There was specifically a clause in that custody agreement that stated something to the effect of a child having special needs. We don't know what it means, but we haven't seen it. As far as like everything with Tylee, that clause is not specified anywhere. So
it's a little
right, and we know JJ had special needs, so it's interesting to see Joe say that. I'm almost to this file.
The rest of it was like basically what? Custody modification. Joe doesn't have to pay Lori's attorney's fees, and Lori is responsible for $3,500 of Joe's attorney fees, which probably really ticked her off.
Mhm.
Tylee's to live primarily with Joe in Arizona. And the
Yeah.
court, yeah.
So Tylee was supposed to live with Joe in Arizona, but she didn't. From my understanding, Christina, I don't think she did. Did she? Lori took her to Hawaii.
Lori does what Lori wants to do, and then she deals with. You know what Lori's motto is, and I mean sometimes this is good, except if it's court order. She's like, "Don't ask permission, ask for forgiveness," and she's not asking for forgiveness from Joe. She's asking it from the court. She does whatever she wants and worries about the repercussions later.
Mhm. Mhm. It's it's something else. So she took her to Hawaii anyways. She took her to Hawaii, and there's more documents we're going to discuss in another live, not tonight because we've been on forever. But it's interesting that Tylee was in Hawaii. These documents do go on. There's, of course, other things we'll talk about, like things like Tylee getting home from Hawaii and not having any sleep. Whoa, any sleep. Um, right before she had to go to school in a couple hours, that kind of stuff. So there was some serious concerns going on. But what's really interesting is that they returned from Hawaii and then just a few short months later, Joe was dead. So
It's weird how that happens around Lori.
yeah. Yeah, like Christina said, we don't know for sure if she was ever able to live with Joe. We don't. It was court ordered that she was supposed to live with
Right.
Joe. But if you look at everything that we know, it looks like Tylee was in Hawaii. And there's other stuff within these documents again that we'll discuss on another live about Tylee going back and forth from Hawaii. So Glowing Ember. How long from the time child support for Tylee was halted did Joe die? So let's look at that. This order is dated 8/28/2014. It says father's obligation to pay child support is terminated, and Joe died early April 2018. So a little over like 3 years and 8 months. 3 years and 8 months later, he was dead. Around there.
He actually lasted longer than. I mean, I'm not trying to be funny. I mean, that happened. It happens quicker with other people.
Right. Right. Christina has a good point. October 2015, Joe posted a photo of Tylee, and someone did comment about the void in his life and his heart, which leads me to believe she was with Lori by then in Hawaii. So it's interesting, and it's a lot to think about. It leaves you pretty drained when you read through this stuff and trying to piece it all together and just understand how in the world Lori got away with this. I mean,
I'll never understand it because I mean, this is, I mean, obviously, this is like a big, like a big giant, like landmark example of people getting away with things that they shouldn't. And and specifically in the legal system. I'm not even talking about all the other
mhm,
stuff, but in other places, in other cases, you see this stuff all the time. Like, you always see the mom who's trying to get her, like, honestly, like the mother that knows that something is not good is going on at her husband's house, and she's constantly going to court, and like nobody listens, and then there's a tragedy,
right.
or vice versa, or the child that, um oh my gosh, the one that they did the Netflix documentary about. His name is escaping me. Little
Gabriel
Yes.
Gabriel Fernandez.
Yes.
Yeah. It's I don't know. It's crazy to me because Lori, first of all, she had connections in Arizona. We know that, right?
Right.
Um, and then you see the things that happened in Texas. So you have to wonder, did she have connections deep enough that allowed her to get away with this stuff? I'm
I
not I'm not saying she did. I think it's worthy of questioning though.
I don't know. It's definitely worthy of questioning, definitely. But I will say that you just see this stuff on a regular basis, and if a woman can manipulate a judge enough and build enough history with, people within the court system, and basically what it looks like is, although they didn't seem too intimidated, but the social worker started like rising up against her, right? But I think she
Mhm.
kind of like pranced around and postured, and she had these attorneys, and the judge just couldn't see the forest for the trees because Lori looked like, although I think she looks disgusting because I know who she is. She probably looked like a little Barbie doll standing there, and nobody could believe that she would be this person. She was just a
Right.
mother trying to protect her children.
You know what's crazy though is I know somebody very, very well who happened to marry somebody very affluent. I'm talking like Hollywood affluent, okay?
Mm-hmm.
And they were together, they had a child. I don't want to tell the whole story, but let me try to tell it this way. He decided he wanted a divorce and didn't have the nerve to tell her, and basically one day said, "Hey, I'm taking our child to breakfast. You sleep in." A
Mm-hmm.
couple hours later, there's a knock on the door, and this person is served with divorce papers. And her husband and her child are still gone. She tries to get a hold of the husband, right?
Mm-hmm.
Can't get a hold of him. He was driving cross country back to California with the child. This person had to get an emergency court order, fly out to California, and get her child back. So when I think of that, and I'm like, okay, so this involved, and when I say like Hollywood affluent, I mean Hollywood affluent.
Right.
Like very, very, very live in Calabasas in a gated community. Um, has a deep, deep connection to films that everybody is very aware of and a lot of money. And this person that I know is just an average person, you know?
Mm-hmm.
So if she was able to get her child back from her husband who essentially kidnapped her and took her across the country,
Mm-hmm.
how does Lori, and that husband is, really deep rooted with lots of family in Hollywood and money and all that stuff. How did Lori get away with this?
Because Lori is a master manipulator.
Yeah. It's crazy. Brenda McCarver said, "Do we know what the job opportunity was that Charles was offered? Wasn't it like a juice bar or something?" But
Yes.
what's crazy is so Charles was basically an entrepreneur, right? He was in the insurance industry. He was in a marketing industry, and both of those industries would allow him to work from wherever he was
Right.
located. So I don't really buy the juice bar story.
No. No. That was just an investment he made so they could move out there and he could appease Lori.
Right, right. It's crazy. I'm just
And
reading
God knows
some.
what she was telling him.
Right,
Yeah.
right.
The other thing, they're
Um,
always running another side and then keeping the two as far apart as they can when they're not, trying to beat each other up at a Barnes and Noble, or a brother isn't tasing someone.
Wendy Johnson said, "But don't you think the courts favor the mom?" Well, I think people tend to believe that.
Not all the time. I've seen the absolute reverse.
So have I. So have I. And
It's a case by case thing. And I think that probably you see more press about, the courts favoring moms than you do the courts favoring dads. But I have personally seen courts that you cannot believe the dad is getting away with the stuff that he's getting away with.
yes, I've seen it go all three ways, actually, to be honest.
Right.
Well, all four ways. I've seen it to where the dad's getting away with stuff and the mom's getting screwed. Then the mom's getting away with stuff and the dad's getting screwed. Or I've seen people be able to have amicable co-parenting relationships, and that is a great thing when you see that.
It is.
And then I've seen where there's, just the other parent, whether it be the mom or the dad, they just don't care. So I do think it is case by case.
It is, and it depends on the judge, and it's everything. There's too many variables to like make huge generalizations. I think it's more of what like we're exposed to, like maybe in the media in our social circle.
Right. Right. So it's I don't know. I don't know. There's a lot of things that I think getting these legal documents, while it's been eye-opening, it's also brought up like a million more questions. 144,000 more questions.
Right. All just walking towards you slowly in a zombie-like fashion while you're trying to sleep.
Yes. Yeah. So, oh yeah, Amanda. The Betty Broderick story case is an example of things not working in the mother's favor. Absolutely.
She didn't help herself, though. I will say this, and I mean, I followed that when it was going on.
Mm-hmm.
I realized that he gaslighted her, and which is a loosely used term, but he was the definition of it. But to some of the things she did, she fell right into his web.
Mm-hmm.
Now it backfired on him in the end, literally.
Mm-hmm.
But she had no self-restraint. She had her own issues as well. They were two people that should have never been together. They knew early on in their marriage they shouldn't have been together, and they stayed together for the wrong reasons. And they each had their own wrong reason for staying together.
Are you talking about Betty Broderick?
Yes.
Yeah. Yeah, that's crazy. So, moving on, let me pull this slideshow down. We'll show you guys this other part because I believe we had shared in a couple places that the investigation of Joe Ryan's death has been reopened by the FBI. And we have this. I just got to get into it and get it going so everybody can see it. And we'll tell you where you can actually find it because it's not ours. We spoke with these great ladies and got permission to share this with you tonight. Some of you may have already seen it. I know that we had not seen it, and a couple other people that I know that follow this case had not seen it. So we're just going to share it here. I got to get it pulled up.
No worries. I'm going to look over.
This is a whole nother discussion within itself.
Yeah.
Well,
let's see. Yeah, Leah, I saw your comment earlier. You said here in Australia, the less you allow a child to see the other parent, the more money you get. Thus, in evil hands, this can create massive issues. It's semi-similar here, although I will say it's not like the parent allows, it's the court. So it can be the less custody you have, the more money you pay. Usually.
Right. And in the same respect, I've seen it, and I'm wondering if Lori was thinking this. She probably thought that by having 50-50 custody that she would still get a good chunk of change by not having a job.
Right.
Because a lot of times when there's joint custody, one parent is still paying child support because the parent that makes more money than
Pays
the
more.
other parent, there's a
It's like
there's
a
a
work. It's like a worksheet. I,
right.
I hear people all the time say, "Well, that's ridiculous." Like somebody will throw out a number. That's ridiculous. It's a worksheet, and there's
Yeah.
really, depending on where you are, there's no negotiating. There's no ambiguity about it. It's whatever the math problem ends up being. Christina says Lori was 100% a manipulator, but at the same time, she had several standing in her corner, enabling her and allowing her to continue this path, regardless of all the bright red flags slapping them in the face. Yeah, it's true.
Right.
And you got to figure out that too, because she had those people under her spell. I'm just gonna use that term, but I mean, pretty much I don't know another term for it, but she ran her campaign on them too. They
Mhm.
weren't seeing her for who she really was. And at some point, not that Lori had something on them, but she had power over them. And whether it was pride or whatever, they weren't going to walk away, even if they saw it.
Right.
I mean, you see them now, they're still denying it.
Right.
So let's see.
Yeah.
Yeah, so Blonde PT, I made a lot more money than my husband had joint custody. He was responsible for only 30%. Yeah, it's because it's a math problem. Luna girl, thank you. Children, oh, you retracted your message. Well, I liked what you said. I won't say it since you took it back. But um let's see. Is Joe's sister pushing for them to look into his death? When did they reopen the case? Yes, she was.
Okay, so on the screen, this comes from the creators. I believe they have Facebook groups, Vodka and Crime. They obtained the toxicology report of Joseph Ryan that was just recently done. And it's
Which
interesting
was
to
pretty
read.
amazing. Yeah.
Yeah, yeah. So shout out to them. You guys can find them on Facebook. I believe they have a Vallow group. I don't have the link in front of me right now. I'm sorry. I'm extremely tired. Like my contacts are all dry in my eyes. And anyways, they obtained the toxicology report, and it's interesting when you read it because there were some medications in Joe's system. One of them being, let me enlarge it on my phone here so I can read it. Diphenhydramine, aka Benadryl. He had 4,400 milligrams per gram. He was also had the drug Flexeril, 260 milligrams per gram in his system, as well as citalopram, which is Celexa. He was also he had, what else did he have? Tylenol, caffeine, ibuprofen, and there was another one, and I know I discussed this with Christina the other day, and it's completely escaping my mind what that one is again, so I'm going to have to look it up. It is called norcyclobenzaprine, and that is actually a breakdown of another medicine. It breaks down in your body as a different metabolite. This was all taken from Joe's, when they did his external autopsy, they actually preserved some liver tissue and I believe thigh tissue, which we did not know about. It is listed on the external autopsy, and that is in our Facebook group. So this was just recently done. It was initiated. Let me find the date that they did this. Oh, I'm sorry. That's that last one I listed. That that medication that is norcyclobenzaprine, that is a chemical breakdown of Flexeril. So it's the same medicine, it's just a different metabolite.
Right. And it's dated June 8th, 2020.
Yes. So just this past June, about 6 to 7 weeks ago, this was completed. We are gonna post this in our Facebook group. We did reach out to the Facebook group that has this and ask them for permission to share it. They know that we have it. We like to be respectful and make sure that we give credit where credit is due and not remove watermarks and stuff like that, because we know we all work hard. So we are very thankful for them getting this, because it's interesting to read when you read these levels that were in his system, and then you see Flexeril along with Benadryl. We don't know if those were prescribed to him. We don't know, but we do know that this is being investigated, and clearly the FBI went back to the coroner who did Joe's external autopsy only, and they pulled the tissue samples and they ran toxicology on it.
Mm-hmm.
Hopefully, I mean, it's my belief. I can't prove it. It's just speculation on my part, but it is my belief that he was murdered. It is 100% my belief. And what's hard about that is that Lori was listed as the next of kin and had him cremated. So it's not like his body can be exhumed like Tammy Daybell's was.
Right.
Thankfully, though, they did have these tissue samples. So it will be interesting to see what comes of this. It'll be interesting to see if he had a prescription of Flexeril, or even when they searched his apartment. I'm sure when he was found dead, there was a criminal procedure that was followed, an investigative procedure, I should say, that was followed upon finding him dead in his home. There should have been a death investigation. So it will be interesting to see if there was Flexeril in his house, if there was Benadryl in his home, along with the digital trail. We talked about the digital trail, I believe, on Web Sleuths.
Mm-hmm. You did.
And how Joe Ryan just died. He's only been dead a little over 2 years. So the digital trail, I'm sure, I actually have very little doubt that the FBI is looking at any digital trail that Lori, Alex, and even Charles Vallow left behind during that time frame.
Right. So, cell phone pings, purchases, GPS in cars, if that's available, anything like that. Plus, I mean, not only, well, actually, you could track Joe's purchases for like OTC drugs.
Mm-hmm.
Because they do that now. There's codes when you buy things, and there's third-party people that track that, whether you like it or not, unless you're using cash.
Mm-hmm.
But and then all his medical records to see what he was actually prescribed.
Right. And, I'm sure, I would assume that when Joe was discovered, his cell phone was in his apartment, in his home. So I'm sure that law enforcement took that. They should have legally. Mm-hmm. They should have taken that and preserved it. And I think what's really disappointing about this is that there was no internal autopsy done. That's upsetting. That drives me crazy. Because
and there's no going back.
Right. There's no going back, and his cause of death was listed as like cardiovascular disease. I mean, it's very similar to Tammy's, and I find it very troubling. Unfortunately, I have had the experience of dealing with a family member having an autopsy and dealing with a family member being found dead in their home. So I know a lot of the procedures that happen after that occurs. And it just blows my mind that only an external autopsy was done. Blows my mind. I suppose it's different by state what the laws are, but where I live, any unattended death of somebody of a young age, and Joe was only, gosh, what was he when he died? Like 57.
Yeah, he was
So,
young.
so very young to just die in bed.
I don't know all the laws in the different states, but I know here recently I heard some people talking about how they had a family member die in their home, and of course they called 911 and all that stuff, and and they did a very basic autopsy, and the family had to request like a thorough autopsy.
Mm-hmm.
And I wonder if that would have been maybe the case here, and because Lori was like, "Hey Joe," you know, she just,
Right.
"Hey Joe, I'm gonna have you cremated, okay?"
Yeah.
And then it was done, and legally, she didn't, you know, cremating him right away. She wasn't breaking any laws. So,
Right. But see, it must depend on state. I'm actually going to look that up. I'm going to look it up for Arizona because
mhm,
here and multiple other states that I know, it doesn't matter what the family wants.
right.
You have no
Yeah.
say in it. None.
Yeah. So I do know here that like you can sometimes they don't even do one, and you have to request it.
Right. Right. So
So,
yeah, it's definitely got to be a state law.
mhm.
So yeah, this toxicology report is interesting. I'm actually posting it in our group right now as I talk. And again, thank you to Vodka and Crime. We are very thankful for you guys getting these documents
Yes.
and allowing us to use them. Thank
Thank
you.
you.
I'm sure some of you guys down there are in their Facebook group. I requested to join tonight. So, um,
I did too. I want to be a member too.
yeah. So what do you guys think about that? What do you think about him having Flexeril and Benadryl? That Benadryl level was very high. Very
Mm.
high.
These women love their Benadryl, don't they? And don't you see Benadryl like all the time?
Yeah, and what's interesting is that in the documents, the court documents between Cheryl and Charles Vallow, one of the accusations,
Was
I,
that
I don't
she?
yeah, I don't even want to say accusations, I guess, because Charles' sons said
Mm-hmm.
that they were being forced to take Lunesta,
Mm-hmm.
which is a sleeping pill. That's a prescription sleeping pill. There's other instances within the Texas custody dispute between Lori and Joe where Joe said he thought Lori was drugging Tylee before sending her over for visitation because Tylee would come over very lethargic and
Mm-hmm.
tired and fatigued and those kinds of things.
Right. The dark circles under the eyes, all of that stuff.
Right. Right.
Yeah.
So
You've seen that. You see that in other cases with like toddlers, um, like family members. Like we'll say that um, Tote used Benadryl.
he did. He
So
did.
it's
Yep. It's crazy. I'm very curious to see what will happen with this. I really am. I'm 4,400 milligrams per gram is that looks very high to me. Very high. So hopefully the investigation when Joe was found was done properly. Hopefully there was pictures taken inside of his home, everything, his medications were gone through. I want to know if there was Benadryl in his house, if there was packets of Benadryl by him, because I worry that they might be like, oh, well, it was a suicide, and I would never believe that. Never
right.
believe that. Um, I don't know. I don't know. So poor Joe. That's all I got. It breaks my heart. Absolutely breaks my heart. It's hard to read all this, you guys. It's so hard to read it all, and it's so hard to, like, you're reading it and you just
Well, and you're also thinking Lori is just recently, I mean, really recently been detained.
mhm.
You know, I mean, it's taken all these years, and she's still not charged with murder.
Right.
Yet she has a lot of people around her that are dying under,
Thank
suspicious,
thank
suspicious.
you, Blonde PT. Thank you. Somebody said it. That's
It's
176 Benadryl.
Benadryl. Yeah. Yep.
So, how did he get that much Benadryl in his system?
And don't Joe? I don't know. I mean, I can't really say this, but this is just my opinion. Okay, Joe's a communicator. I think if Joe's going to kill himself, he's not going to leave a note with his attorney. He's not going to write a letter to Tylee for her open when she's 18. He's not going to. Do you know what I mean?
Right.
It's not within like what we see of his character and his history. It's
Right.
just not.
No, and he loved his daughter above all else. You can look on his
Right.
Facebook page. You can
Right.
look at the thousands of documents we've gotten. This man, I've known people that have given up on fighting for their kids
Yeah.
because of situations not near as extreme as this, but to go through any type of custody battle is absolutely exhausting, draining, both mentally and financially. And he never gave up on his daughter. And I would never for a second believe that he took it.
Well, I mean, you and I were just talking the other night, and I was explaining that I knew somebody that terminated their parental rights when their child was like under 12 months old.
Mm-hmm.
And I wasn't really sure why. And I found out the other night, I got some clarification. And apparently, because I just had a hard time reconciling that, like why that would happen, like why you would do that. And it was because the thought of dealing with that child's mother for the rest of his life, he would rather terminate his parental rights. And it's a very strong statement to make.
Mm-hmm.
You know, and Joe didn't do that. And I don't think Joe would just leave Tylee on this earth alone without an explanation. I just don't believe he'd do that. He fought too hard.
Mm-hmm. Yeah, I don't believe that at all. And like Christina said, he had a history of hyperlipidemia, which is high cholesterol, hypertension, high blood pressure, depression, and back pain following a fall from a ladder. Um, I mean, I think it's easy to see why anybody could be depressed after what he went through. And he was on citalopram, which is Celexa, so he was treating his depression, and his medication levels from looking at this with the Celexa look therapeutic. It looked like he was taking his medicine like he was supposed to, and
Right.
he didn't have an excessive amount in his system.
Right.
So, um, that's a good question, Connie. Did he have the pink foam like Tammy Daybell? I don't think we know that because when Joe was found, he had been dead. I think they said a couple weeks, or he had been dead for a significant amount of time, so he had
It's
began decomposing when he was found.
unimaginable as well.
Mm-hmm.
Yeah.
Yeah. So it's a lot to take in. But seeing the Benadryl in combination with the Flexeril like made my heart drop because you have Benadryl. We all know what Benadryl does, right? And then you have Flexeril, which is also another relaxant, muscle relaxant, and the levels are pretty high on that Flexeril. So, yeah.
Was
Yeah.
was he it was stated that he's like had did he have the Celexa for depression or did he have it for like pain management off label? Do you know?
I don't know. I would imagine
Because if
depression.
okay, because when you said the latter fall, because they do prescribe it now, fair like in the past couple of years, fairly regularly for pain management too.
Huh. I didn't know that. I've never
Mm-hmm.
seen that. Um, Wendy Johnson, didn't Alex have pink foam? Oh, the chat moved on me. Didn't Alex have pink foam as you thought you heard that? I don't remember if we know if he had pink foam. I know that he had defecated on himself, and Christina might be able to clarify that. That would be amazing, Leah, if that would happen. We we should probably reach out to him, Amy.
Yeah.
Would former Atlanta Medical Examiner Office Senior Investigator Joseph Scott Morgan come on your show, ladies, and discuss those toxicology levels?
Well,
Trisha has his contact. We will see what we can do. That would be
we
amazing.
could extend a verbal invitation.
Yes.
We would
Joseph,
be very grateful
we would.
and humbled. So,
Yes.
if you're listening,
Yes. Yeah. Um yeah, Slam RN. I didn't know that about Celexa either. I'm also in healthcare. So I didn't know that. That's interesting, Amy.
I only know because I know two people that take it that way.
Gotcha.
So,
How did Alex die? Slam RNS. So
it's for it's I always have trouble with this word. It's like for neuropathy.
neuropathy.
Mm-hmm.
Hmm.
Like yeah, like nerve pain.
Yeah. What I'm sorry. Mary Duffy Deals. The antabuse he was taking also caused tiredness. What is antabuse and where did you see that he was taking that? Um,
Antabuse is that drug you take when you're trying to quit drinking. It makes you like, isn't it the one that makes you sick when you drink alcohol?
I wasn't aware that he was still taking that though.
I don't know anything about that at all.
Yeah, I never heard that. I thought I was under the impression that Joe's history of drinking, that was brought up like way back when the custody battle first began, and he had basically stated that he was not abusing alcohol anymore. I'm not privy to any informations. Oh, okay. Christina, you commented a list of medications found in his apartment. That's where that comment comes in. Okay. I missed your comment. Sorry. I'll go up and find it. Slam RN, but before I find that, asked, how did Alex die? You are confused. So Alex kind of just fell over in his apartment, and they said they did say he was foaming at the mouth, I believe. Sorry guys, it's late. I'm tired. He also, he lost control of his bodily functions, and his autopsy came back as he had bilateral pulmonary embolisms. So let me find Christina's comment with the list of medicines. I think we're going to wrap it up soon.
Just looking at something here.
Oh, I don't see it, Christina.
I don't see it either.
Did you comment it in the group? I'm sorry. Hmm. Yeah, I don't see it.
Me either.
I don't know.
You know what's interesting is I think somebody just said it. I was like kind of waiting to say it, but somebody else said I think Charles is the one that quit drinking. No, Joe was, you know, accused or mentioned or whatever to have issues with alcohol. But I find it interesting that um, both Charles and Joe were both accused of the same things or had the same things going in their house by different people, but Lori's the common denominator. So,
Right.
whether it's their children doing things that are improper sexually or abusing alcohol or but not that taking antidepressants is bad, but they like to bring that up. Um, those kind of things. Charles had bipolar disorder, blah blah blah.
Oh, there was no Benadryl found in his apartment.
Oh, well, that's a
Okay.
problem.
So amoxicillin was found. Citalopram, that is what was found in his system, but it says escitalopram. It's the same thing, basically. Cyclobenzaprine, that is Flexeril. Hydrochlorothiazide, that is HCTZ, also known as a blood pressure medicine. Lisinopril is a blood pressure medicine. Atorvastatin, that is a high cholesterol medication. Let me look up this other one because I'm not understanding what that one is off the top of my head. The disulfiram. Okay, so that is the alcoholic. That is the medicine they're
It's
talking about.
abuse.
Yeah, antabuse. That wasn't found in a system. That's interesting. No Benadryl was found in his apartment, but he had a high Benadryl level on that tox screen.
Yuck.
Yeah. Yeah. Crazy. So, I don't know. Let's look at the chat, see what's going on down there. And I think we're going to call it a night here. We've been on here 3 hours and 11 minutes.
Yep. It's a long one, but it was a good one. Oh goodness. Sorry.
Sofatato, was there alcohol found in his apartment? I don't know. Christina might know. Glowing Ember, you said you think Charles is the one that had quit drinking. I think they both quit drinking according to court documents.
Yeah. Yeah, gabapentin can make you tired. That's like a major side effect.
Leah. Oh, thank you, Trisha. Leah, no, this was never considered a suicide. I had just said that I wanted to know what medications were in his home, and I hope that nobody would consider this suicide because I don't believe that he would ever commit suicide. So sorry if there was any confusion. Yeah. Una of a kind art. Is that supposed to be one of a kind art? Maybe, I don't know.
Yeah.
Benadryl and muscle relaxants. Those aren't a good mix. Yeah, everybody tell Trisha hi. Web Sluice is down there.
Hi,
It would be
Teresa.
great to talk to Joseph Scott Morgan. We would love that. Glowing Ember. The babysitter did not say that Lori gave JJ Benadryl to make him sleep. The babysitter said that Lori gave her JJ's prescription of risperidone and told her that if she needed to give it to JJ early, that was okay because Lori often did so because it would make him go to sleep. Basically, Lori said when she didn't want to deal with JJ later in the night or, getting closer to bedtime, or I don't know what Lori's nightly schedule was, but Lori basically said that she would give JJ his nighttime risperidol, same medicine, earlier than his schedule was. So Christina said there was no evidence of abuse, alcohol, tobacco, illicit substances, or prescription medicines. Thank you, Trisha. Yeah, the high doses of risperidone is toxic. I think that will be interesting to see what comes back on Tylee and JJ's autopsies. So,
I'm not gonna say it.
what? No, say it.
It was interesting to me that there's a lot of other medications for autism. I mean, they, you have to find your cocktail or whatever, but the trend now is that people don't want to use risperidone, especially in boys, if they don't have to. And there's other drugs that do the same thing, because it causes them to have breast development. It alters their it affects their whole like pituitary system and stuff, and it's just one of those things that you see across the board. Like, there's still a lot of people that use it, but a lot of people are concerned with their male children using it.
Okay.
Um it's just weird to me that she would so concerned with like different things and images and stuff that she would have her child on that, because there are other ones like they use Abilify. That's one that they use quite often.
All right, guys. I think we are gonna say goodnight. All of the links are down there. These documents will be on our Patreon soon. It's gonna take us a little bit longer to get them on there because they are a bunch of different files. We got to work some magic. And all of the links are down in the chat to our Facebook groups, our Instagram, our Twitter, our main Facebook page, our Patreon, all of the above. Our email address is wickedtruths@wtaf.net. And a reminder, we will be live tomorrow in regards to the triple homicide in Frostproof, Florida. Time to be determined. We don't know what time we'll be on live yet, but we'll get that info up.
We also started a new group today. Should we talk about that real quick?
Yeah, we haven't even really done anything in this group yet. You can give them the rundown if you want.
Okay, so we started a new group. It's Hannah Potts. It's out of Princeton, Indiana. And here's how the story goes. She leaves a video on her Facebook page stating that she's been kidnapped and she hasn't been seen and the FBI are involved. And it began around, 2 a.m. on, what is today? Is today Saturday?
Technically, it's now Sunday.
Well, now you made it more confusing. No. Oh.
Sorry.
Good night, everybody. I believe it would have been like 2 a.m. on Thursday night. And yes, because they did 2 a.m. Friday. And then they did this a first search the family did 9 a.m. this morning. As of last night at like 5, or early this morning at like 5:30 a.m. there was no press on it. You couldn't find anything anywhere. You couldn't find it on like police blotters or anything like that. And now the FBI is involved. So we started a group on that. There's a little bit of information in there. It's going to grow. So definitely check that out. But yeah.
Yeah, we're still looking into that one. So if you join the group and there's only like 6 posts in there right now, please don't give up on us because we're going to get it up and going. We've had a lot going on today with the Frostproof case and then all of this with the Vallow case. So
the new documents, the toxicology report. Have you eaten today, Danielle?
I don't think I have.
I haven't. I'm on like it's disgusting. I'm on my like 7th Diet Coke today.
You guys, I might be able to make a run for the border because I think they're still open, right? What time do they stay open till? Or
No, but it's time for 4th meal.
yeah, it's time for
But it's,
fourth meal, but it might be affected by the C word. So
oh, I don't know what C word, and I'm not saying it here. What's the C word? Oh. That
yeah, I
Mexican,
wasn't talking about anything inappropriate.
that Mexican beer virus. Yes.
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 Yeah. So, on that note, we're going to say goodnight, guys. Thank you, VP Hussy Mouse, for your super chat. Thank you so much. And to our amazing mods, our bomb squad, as we call them, make sure everybody shows them some love. We're so thankful for them.
Yes, thank
They work,
you.
they work really hard down there in the chat.
Yeah, you guys don't even know how hard they work. They not only in the chat, but out of the chat.
Yes.
So.
All right, guys. On that note. On that note, good night. I'm going to get Taco Bell.
All right. Good night,
Bye, guys.
everybody.